Okay, let's hope this worked. Sherry, are you here? I feel like I'm deja vu. I'm like, oh no, is this not gonna work again? But it better be working. Let me see. It looks like it's working. Can you hear me, Sherry? Can you hear me, Sherry? Yay! So we have some happy joy. So we have some new court filings to go over here from the Maya case. I know that I just fired up this live. No advance notice at all, because I'm just like that, you know. Everybody was talking about all kind. I wanted to have a Christmas party or something, and a movie night. So I just want to make sure that all's good. Let me see. I can tell right away. So should be able to hear. Oh, you know what? Hang on. I know why. There we go. So we have some new filings in the Maya case. The plaintiffs have filed a response. So I'm going to pull that up over here. And if you missed Donna Adelson, because we went live like 6 times about it today only, and only one time was, we had to, oh my gosh, all the work we had to do today. But anyway, we did it. We survived. We're here. So let's see. 1211, there's in the notice of filing, the hospital regulations in support of response to post-trial motions. Notice of filing exhibits in support of response to post-trial motions, and then response to post-trial motions. So the first notice is let's see, let me pull this over. Okay, there's Margot. Here's Bucky Ann. Everybody's coming in now. So this is JHACH Kowalski. Oh my gosh. I got tongue twisted tonight. JHACH Kowalski. I have mince in my mouth. Okay, as parent and next friend of MK, a minor, and JHACH Kowalski as personal representative of the estate of Beata Kowalski, deceased. Plaintiffs versus John Hopkins All Children's Hospital, Inc., defendant. Yeah, planning the Christmas party. Okay. Plaintiff's notice of filing hospital regulations in support of response to defendants' post-trial motions. Plaintiffs hereby file the attached state laws, federal laws, and the Joint Commission regulations. We're not going to go through those things, okay? Exhibit 1 is the licensure inspection. Inspection. Okay, research, reference, and practice aids. Exhibit 2 is the internal risk management program. Okay, and talks about, we're going to go through the other documents first, but I'm just going to take a look at this, okay? Healthcare law, research, reference, and practice aids. Exhibit 3, liability of healthcare facilities. Exhibit 4, investigations and license, life safety, and validation inspections. Exhibit 5, governing body. Exhibit 6, incident reporting system. Exhibit 7, federal deemed status fact sheet. Exhibit 8, condition of participation, governing body. Exhibit 9, condition of participation, quality assessment, and performance improvement program. Exhibit 10, revised requirements based on CMS final rule. Okay, now let's go to the next. Hi, Ralph. Hi, Deborah. Okay, so we want to get to the real crux. This is still not it. I think it's the third one we're going to be looking at. This is okay. This next, let me pull this. I'm going to open the third one too, okay? Which, we're going to go through this one first, I think. All right, let me just fix my little hold on a second. Oh, it's okay. Something felt like there was a cold blast or something. Let me fix my chair because I think it's sunk down. Okay. Forget what my son called me today. He and Gia called me and they said, Mom, what do you want for Christmas? And I said, are you shopping right now for it? And they said, well, we're shopping right now, but you don't have to make your mind up right now, but pretty soon. I swear to you, a couple of weeks ago, I said the same thing happens to me. Every time Christmas rolls around, I don't know what I want. But then this year, there was like, oh gosh, that's great. And that's something that they could get for me. And now I can't for the life of me remember what it is, but I'm going to have to try. Okay. So, Plaintiff Jack Kowalski, individually and on behalf of MK, blah, 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 blah. Okay, introduction. Defendant's 144-page motion shows defendant still does not get it. Defendant now blames the court and the jury and continues to maintain there was nothing wrong with the way it treated Maya and her family. Defendant argues in its motion that any injuries suffered by the family were not so bad, were the family's own fault, and any harm visited on Maya, Beata, Kyle, and Jack was caused by DCF because defendant was simply following DCF orders. As the manifest weight of the evidence demonstrated, Johns Hopkins All Children's Hospital, through its doctors, employees, and agents, each of whom defendant accepted responsibility and liability for, did the following: negligently and almost instantaneously changed Maya's complex regional pain syndrome diagnosis over the weekend of October 7, 2016, although Maya's diagnosis had been confirmed by no less than 5 outside treating anesthesiologists and neurologists and recognized by the defendant hospital on each and every of Maya's approximately 20 previous visits and admissions to JHACH. kept Maya in the hospital from October 7th to October 13th without legal authority and despite her parents' repeated requests for discharge. Refused to transfer Maya unless her parents signed off on the defendants' suggested diagnosis of Munchausen's by proxy, MBP, and admitted that Beata had a psychiatric condition that led her to physically and emotionally abuse her daughter, only to hide behind its status as a pediatric hospital and claim that it had no ability to diagnose an adult like Beata. Covertly videotaped Maya to try to prove she was participating in a charade to assist in cover for her mother, who had fabricated Maya's CRPS, and in doing so, placed the commode out of reach so that Maya would be forced to get out of her hospital bed when she thought no one was watching. Instead, she defecated on herself and was dragged to the commode by hospital employees. Assigned Catherine Beatty, an employee with at least 3 documented disciplinary and anger management issues, to be the primary overseer of Maya, allowed Beatty to repeatedly engage in unwanted contact with Maya, including hugging, kissing, patting Maya's legs, and placing Maya in her lap. Forced Maya to endure physical therapy without pain medications, and enticed Maya to push beyond her limits by enticing her with the promise of chocolate cake and going to church outside of the hospital, only to be told by Beatty that she had not tried hard enough and would not get chocolate cake or go to the outside church. Routinely interfered with Beata's visitation rights, allowing Beatty to sit in, interrupt, and disparage Beata by making inappropriate faces, rolling her eyes, and otherwise acting like a toddler while Maya was on the phone with her mother. Required Maya to keep her hospital room door open while having what should have been private conversation with her attorneys, Michael Kelly and Mark Zimmerman, and rationalizing this infliction of emotional distress with the implausible excuse that the hospital staff had to keep the door open for fear of Maya falling and being left on the floor by her attorneys. Provided less than 5 hours of cognitive behavioral therapy, CBT, over Maya's 3-month admission, even though CBT was, according to defendant and its experts, one of the pillars of therapy for Maya's CRPS. Forbade Maya from engaging in religious practice despite the hospital's own patient bill of rights and in the absence of any dependency court order authorizing such a prohibition, including removing Maya's religious artifacts from the room, instructing Maya's priest from her family church that he could visit but not pray with Maya, and kicking out members of Maya's church who visited as part of the Legion of Mary with the good faith intent to leave Maya with a statue of Mary to watch over and comfort Mary, habitually lied to Maya as documented in the defendant's risk management file, telling her that her illness was all in her head, her mother was in a mental institution and Beatty would be her mother now, sought to drive a wedge between JHACH and Beata by suggesting that JHACH consider divorcing Beata, forbade Maya from having contact and social interaction with other children on her floor, and further dehumanized Maya by not even placing her name on the door of her various hospital rooms. Refused to deliver gifts that Beata and JHACH brought to the hospital for Maya, including a birthday card to commemorate Maya's 11th birthday and a white Christmas dress, one of Maya's favorites, sent by Beata, both meant to remind Maya how much she was loved since she was forced to celebrate these occasions alone in the hospital. Refused FaceTime calls between Maya and Beata in the last 10 days of Beata's life, despite the dependency court's December 27th order that the hospital facilitate these FaceTime calls twice daily at 11 a.m. and 5 p.m. Stripped and photographed Maya over her objections and tears without her parents' consent and under Beatty's threat that if she did not allow the photos to be taken, she would not be allowed to attend the dependency court hearing later that morning. Conducted a relentless intimidation and harassment campaign against Beata, beginning with the refusal to honor Beata's request for Maya's discharge in the first week, with knowledge that the hospital's actions were driving Beata towards taking her own life and abhorrently predicting Beata's final act. Okay. Having now reminded defendant of the outrageous conduct it refuses to address, none of which was compelled by DCF. Plaintiff will respond directly to the defendant's motion to make this response more manageable. Plaintiff will follow the format and organization used in the defendant's motions. Plaintiff does not, of course, agree that there were errors, etc., as alleged in the defense headings, but to respond initially to some themes in those motions, the plaintiff offers the following. Hi, Julie W. As defendant acknowledged during the trial, this case is unlike any other. Thus, comparisons to other torts and verdicts in other cases, such as where a plaintiff died after a lifetime of choosing to smoke, are of very limited value. Contrary to the defendant's sky is falling claim, that if this verdict stands, no facilities will agree to shelter children, the result here will mean that no facilities will treat a child and her family as defendant treated the Kowalskis, and the Florida Supreme Court long ago rejected the logic adopted by the defendant here, that Johns Hopkins should be given blanket protection by Chapter 39's immunity provision, even though Johns Hopkins violated and abandoned its duty of care to Maya. More than 30 years ago, the Florida Supreme Court addressed this inverted logic in the Department of Health and Rehab Services versus Unumni. Okay. Johns Hopkins All Children's Hospital is no different. Having been entrusted with Maya's care during her sheltering, the hospital owed her reasonable care. The defendant abjectly failed to care for Maya, instead placing her in harm's way of its agent, Dr. Sally Smith, to prove the charade, and Beatty to carry out her perverted motives. Plaintiff repeatedly put defendant on notice of the harm being visited on them, as demonstrated by the risk management records and letter addressed to Dr. Jennifer Katzenstein complaining of Beatty's inappropriate conduct. Yet despite the actual knowledge and foreseeability of this harm to the plaintiff's family, defendant took no action. No child had ever been sheltered in the defendant's hospital for as long as Maya, over 3 months, because Maya's situation was unprecedented. Defendant's dire prediction of the negative impact this verdict will have on other sheltering facilities is unwarranted. Upholding the jury's verdict, however, confirms that the sacred duty to care for children also extends to sheltering institutions, including children's hospitals. This court carefully carved out the actions that were not subject to Chapter 39 immunity. As the defendant notes, the plaintiff moved before trial to take Chapter 39 out of the jury's consideration altogether, by the court preventing any mention of the DCF proceedings. Defendant successfully opposed that motion because it wanted the jury, not just the court, to know about Chapter 39 immunity. Defendant now regrets its strategic decision, claiming the Chapter 39 immunity was used as a sword and not a shield. Aside from being wrong, defendant got what it wanted and cannot now blame anyone but itself. Defendant should be glad the jury did not hear the full extent of it and its counsel's active role in prosecuting the DCF proceeding and urging the dependency court to implement the constraints and restrictions on the family visitation rights that defendant attempt to hide behind during trial. Negligent training. Defendant repeatedly asserts that the negligent training claim should have been directed out sooner, and is another source of its problems. As discussed below, Florida law requires hospitals to have competent staff. Proper training and supervision is part of that mandate. As it notes, plaintiff offered to make that a part of the medical malpractice claim, but defendant refused. Without trying to assess blame, no agreement was reached. But this is all irrelevant because defendant ultimately acknowledged that negligent training was relevant to the punitive damage claims. See November 6, 2023 transcript excerpt at pages 7 through 13. Mr. Alton Burned, there may be some element of this negligent training that relates to a punitive damages claim. So I always kind of listened to this with the same interest that you had. Then I am not sure how it ties into punitive as compared to training, but I'm not going to tell you that I'm 100% convinced that there's not, as you use the word, scintilla of evidence of this that somehow relates to punitive damages. I'm essentially conceding to you that there's a level of this that can be talked about for punitive damages. Defendant has not pointed to anywhere that it requested an instruction limiting the training evidence. Defendant's motion at page 130 acknowledges that keeping Catherine Beatty assigned to Maya's care was a negligent act of supervision or training. As discussed below, hospitals are legally responsible for adequate training and supervision, whether the actor is inside or outside the scope of employment. Specific intent. The question of whether the defendant had the specific intent to harm Maya for purposes of the punitive damages limitations of section 768.731C was properly on the verdict form for the second phase of the bifurcated proceeding per the standard jury instructions. See Florida statute jury instructions 5031C 2A 3Is. Putting the specific intent question on the verdict form in the first phase would have introduced an issue as to the amount of punitive damages before a jury finding that punitive damages were recoverable. Defendant also has shown no harm from this because it has not argued, nor could it, that the amount of punitive damages awarded exceeded the maximum amount awardable under the section. Defendant had the opportunity to present evidence on the specific intent issue in the second phase of the bifurcated proceeding. Despite the court's repeated admonitions that the punitive damages phase would follow directly and immediately after the jury returned its verdict, if it found in plaintiff's favor, defendant apparently failed to prepare its evidence to rebut the plaintiff's punitive damages evidence, and as a result failed to present its evidence at that time. The delay beyond November 9th, defendant requested, was not reasonable and apparently was dictated by the vacation plans of one defense team member for the week beginning November 13th, as discussed next. Defendant's argument that it was harmed by the court's decision to place both options for the burden of proof on the specific intent issue on the verdict form is speculation at best, with the jury not needing to reach the lower standard alternative question, as was done with other items. The verdict was structured to avoid having to retry the case. Defendant's insinuation that it was harmed because the court did not give it adequate time to present its case was never raised during trial, nor did the defendant use all its allotted time to make a request for additional time that the court refused, motion 3-4. The court did not make a definitive pronouncement that the trial could not continue into the week after November 9th. In fact, the court alerted the jury during jury selection that the trial may extend into the week following November 9th. Also, it was defense counsel who expressed reservations about extending the trial due to defense counsel's planned vacation for the week. Just getting a drink here. Okay. Beginning November 13th. Ultimately, the defendant rested its case in chief, having not exhausted its available time. This was the defendant's decision, and it's alone. Damages including non-duplication, instruction, and allocation among torts. The amounts of compensatory damages awarded in this case were supported by the evidence. The jury is allowed wide latitude in setting non-economic damages. Okay. The jury was instructed, although these claims are separate claims, it is possible that separate claims may result in overlapping damages. Your verdict should not award damages twice for the same loss, injury, or damage, even if they result from different claims. Your award of monetary damages for each claim, if any, must not duplicate the same damages awarded in other claims. Defendant did not object to the plaintiff's closing, suggesting the jury allocate the damages flowing from multiple acts by the same tortfeasor along with the torts in the jury's discretion. Allocating among claims is consistent with the multiple events instruction when there are multiple tortfeasors. Jury instructions. Plaintiff had proposed a much simpler verdict form that did not allocate damages among the different claims, which defendant rejected. The plaintiff presented a logical option for the jury to evaluate damages for Maya's physical and all family members' emotional pain. The jury heard testimony that Maya's CRPS is the most painful neurological condition from which a person can suffer. The few numbers defendant did suggest at trial, unsupported by any evidence, were numbers for damage as a whole, such as future medicals, not apportioned by the claim. So it is too late for the defendant now to argue for limits on specific items when it did not share those numbers with the jury. See below under remittiture standards. Contrary to the defendant's conclusory statement, as discussed below, punitive damages bore a reasonable relation to the amount of compensatory damages, and none of the punitive awards exceeded the statutory cap set forth in section 768-.731A. Motion 29. Defendant forgets one purpose of punitive damages is deterrence and does not argue the amount was unreasonable in light of the large amounts of its assets. The jury paid rapt attention to both sides, was respectful to counsel, took copious notes, and asked thoughtful and penetrating questions on both sides. The court religiously reminded the jurors of their duties, and they consistently reaffirmed that they were following them. The court observed that this jury did its job. Jury number 1. A key theme of the motion is that the jury was under the leadership of juror number 1, and the verdict therefore was tainted. This is pure conjecture, as discussed in the plaintiff's response to defendant's motion for a new trial based on the purported conduct of juror number 1. Defendant has offered no facts whatsoever in its motion that showed that any juror acted under the leadership of other jurors. Moreover, a verdict is not subject to attack based on matters that inhere in the verdict, those that arise during the deliberation process. Whether the other jurors viewed juror number 1 as a leader would be just such a matter. Under Florida Statute Jury Instruction 7, the jury is directed to accept a leader in the form of a foreperson as its first act during deliberations. Jurors' ability to understand the case. Finally, another key theme of the defendant's motion is that this case was just too complicated for the jury to understand, and its verdict shows it was confused. The medical and scientific evidence was complex, a difficult, intentional tort for a jury to understand. This high-profile case presented to a national audience would be nearly impossible for most juries, even with a different foreperson. Defendant goes so far as to say that this case is easily 9 times more complex than the normal case. Respectfully, that is nonsense. Simply because defendant was unable to persuade the jury it did nothing wrong does not mean the case was too complex to be understandable or that the jury was confused. Rather, the evidence and the verdict reasonably show the jury astutely saw through the defense. Perhaps the result would have been different had defendant shown even a modicum of contrition or acknowledged it could have handled this situation better. Juries routinely handle complex issues, including lengthy and complicated intellectual property, antitrust, conspiracy, and medical malpractice cases. The jurors' thoughtful questions throughout the trial in this case showed they closely followed and understood the evidence as it came in. The table of contents. In evaluating a directed verdict, the trial or appellate court construes all facts and evidence and every reasonable conclusion or inference based therein in favor of the non-moving party. A directed verdict cannot stand if the evidence is conflicting or different conclusions or inferences can be drawn from it. The court may not pass on witness credibility or weigh the evidence, namely all contrary evidence or explanations on which the defendant seeks to rely must be disregarded as rejected by the jury. Because the full transcript is not available, plaintiff's notes for preservation, a party waived the issue of legal sufficiency of the evidence by failing to move for a directed verdict on the issue at time of trial. Party must timely move for a directed verdict at a trial to serve an effective motion to set aside the verdict and to enter judgment in accordance with the motion for a directed verdict. In other words, the moving party must have moved for a directed verdict on the specific issue at the close of the adverse party's evidence or the close of all the evidence. Excuse me. A directed verdict is appropriate only when there is no evidence upon which the jury could rely in finding for the non-moving party. Notably, a renewed motion for directed verdict cannot be used to test the sufficiency of evidence to support a verdict. The trial judge is not warranted in withdrawing the case from the jury or in setting aside the jury's determination or conflicting evidence and substituting therefore his own evaluation of the evidence. New trial. A trial court may order a new trial when the jury's verdict is against the manifest weight of the evidence. A motion for a new trial is directed to the sound, broad discretion of the trial judge, who, because of his contact with the trial and his observation of the behavior of those upon whose testimony the finding of fact must be based, is better positioned than any other one person to fully comprehend the processes by which the ultimate decision of the triers of fact, the jurors, is reached. However, a trial judge is not free to behave as a super juror by disregarding a jury's verdict simply because the judge would have rendered a different one, had it been the judge's choice to make. In deciding whether the evidence manifestly weighs against the verdict, the trial court must necessarily consider the credibility of the witnesses along with the weight of all of the other evidence. The only credibility question defendant raises in Maya's recollection of the photography session at motion 66 to 67, but there is no question clothing was removed and pictures taken while defendant's staff held Maya down. Defendant does not contend this issue. The credibility of witnesses is a key to the court's evaluation of its new trial motion. As defendant's error discussion recognizes, the trial judge who oversaw the case firsthand is accorded deference. The court first determines whether there was an error, and it so applies the harmless error standard. The court also considers if the evidence was a feature of a long trial. Amount of verdict. Okay, let's see here. Florida statutes state that after a jury awards damages, it shall be the responsibility of the court upon proper motion to review the amount of such award to determine if such amount is excessive or inadequate in light of the facts and circumstances which were presented to the trier fact. The purpose of the remediatur or additur is reflected in section that it is the intention of the legislature that awards of damages be subject to close scrutiny by the courts and that all such awards be adequate and not excessive. In assessing whether an award is excessive or inadequate, the court shall consider the following criteria: whether the amount awarded is indicative of prejudice, passion, or corruption on the part of the trier of fact. B. Whether it appears the trier of fact ignored the evidence in reaching a verdict or misconceived the merits of the case relating the amounts of damages recoverable. Whether the trier of fact took improper elements of damages into account or arrived at the amount of damages by speculation and conjecture. Whether the amount awarded bears a reasonable relation to the amount of damages proved and the injury suffered, and whether the amount awarded is supported by the evidence and in such that it could be adduced in a logical manner by reasonable persons. Although the trial court must consider each of the foregoing statutory criteria, the weight given to each is discretionary. Okay, overlapping these requirements, the court must also review a punitive damage award to ensure that 1. The manifest weight of the evidence does not render the amount of punitive damages assessed out of all reasonable proportion to the malice, outrage, or wantonness of the tortious conduct. The award bears some relationship to the defendant's ability to pay and does not result in economic castigation or bankruptcy to the defendant, and a reasonable relationship exists between the compensatory and punitive amounts awarded. Okay, let's see here. A punitive damage award must further satisfy the federal constitutional requirement of due process by the court's measures of the award according to the degree of reprehensibility of the defendant's misconduct, the disparity between the actual or potential harm suffered by the plaintiff and the punitive damages awarded, and 3, the difference between the punitive damages awarded by the jury and the civil penalties authorized or imposed in comparable cases. The Florida Supreme Court has noted that in addition to the foregoing factors, amounts awarded in similar cases has at least a limited value in determining whether an award is excessive. To characterize this as a unicorn case understates the horrific acts defendant committed in combination to inflict damage on the Kowalski family until the defendant can bring forward a case where the jury found the defendant liable for battery, false imprisonment, medical malpractice, and intentional infliction of emotional distress. Oh my gosh, I can't speak tonight. Distress. A comparison of verdicts in other cases is of limited value. Defendant has not produced even a single case where 3 out of the 5 torts committed here were committed simultaneously by one defendant. The defendant suggests this case should be compared to smoking cases because of the size of the punitive damage award. But those cases were adult smokers voluntarily engaged in conduct once the dangers were well known and not remotely like what the defendant did intentionally, as the jury found, to this young girl and her family. Defendant cites 2 commercial cases addressing damages. Okay, let's do that. Even the primary case, we don't need to go through that. Defendant frames the legal question this way: whether the verdict is so inordinately large as obviously to exceed the maximum limit of a reasonable range within which the jury may properly operate. Defendant never gets around to demonstrating to the court what reasonable range the jury could have properly operated within, and cannot make such a showing from the record, since the defendant failed to put on any evidence suggesting an appropriate measure or range of damages. Likewise, the defendant cites no false imprisonment, battery, medical malpractice, or intentional infliction of emotional distress cases to demonstrate a reasonable range. Defendant also fails to mention that Gould also reiterated that a party who assails the amount of a verdict as being excessive has the burden of showing it is unsupported by the evidence, or that the jury was influenced by passion or prejudice. Okay. The Florida Supreme Court emphasized in bold that there is an element of speculation in most personal injury verdicts, but that is a matter for the jury's discretion. The court may review their discretion, but not the amount awarded unless shown to be clearly arbitrary. The determination of the amount of such damages is peculiarly within the province of the jury. In fact, the defendant's arguments throughout the remainder of its motions demonstrates that the jury's verdict was consistent with the per diem calculations plaintiff suggested, and though defendant complains of the methodology, only an award in line with the defendant's closing argument would have been arbitrary. Defendant's suggestions in closing were drawn from its hip pocket rather than being based on record evidence. As discussed below, the plaintiff's evidence provided a basis for the jury's award. The expert testimony provided a range for the jury to exercise its discretion in awarding both the medical and lost earnings damages that would exceed the numbers blackboarded. Deference to juries continues under the statute. Notably, section 768.64.6 makes clear that the statutory review of jury awards by the court is not intended to replace the discretionary authority historically given to juries, and that the legislature recognizes that the reasonable actions of a jury are a fundamental precept of American jurisprudence, and that such action should be disturbed or modified with caution and discretion. Because of the inherent difficulty in measuring these kinds of non-economic damages, this court has determined that the jury, guided by its judgment and everyday life experiences, is in the best position to make a fair assessment of these damages. The extent to which a jury could have believed or disbelieved certain witnesses when coming to its verdict on damages is a factor the court can decide in deciding to give deference to an award. The deference to the judgment of juries has been recognized specifically regarding damage awards in a wrongful death action, because who can place a dollar amount on a human life measured by the loss and grief of a loved one? The difficult decision is generally one for the jury or a fact finder, not the appellate court. Likewise, the wide latitude accorded juries in determining the amount of awardable damages has been especially true of punitive damages awards, which are peculiarly left to the discretion of the jury, as the degree of punishment to be inflicted must always be dependent on the circumstances of each case, as well as upon the demonstrated degree of malice, wantonness, oppression, or outrage found by the jury from the evidence. Accordingly, the jury's wide-ranging authority to determine these damages has long been subject to limited trial court supervision through the post-trial order of the remediature or new trial. The underlying rationale for such a limited superintendence is so to prevent so-called haywire or runaway jury verdicts from standing. In keeping with these precepts, the Second District articulated its concern about reducing jury damages awards in tort actions as follows. Where recovery is sought for a personal tort or where punitive damages are allowed, we cannot apply fixed rules to a given set of facts and say that a verdict is for more than would be allowable under a correct computation. In tort cases, damages are to be measured by the jury's discretion. The court should never declare a verdict excessive merely because it is above what the amount which the court itself considers the jury should have allowed. The verdict should not be disturbed unless it is so inordinately large as obviously to exceed the maximum limit of a reasonable range within which the jury may properly operate. The fact that a damage award is large does not in itself render it excessive, nor does it indicate that the jury was motivated by improper consideration in arriving at the award. The record must affirmatively show the impropriety of the verdict, or there must be an independent determination by the trial judge that the jury was influenced by considerations outside the record. In other words, the trial judge does not sit as a seventh juror with veto power. His setting aside a verdict must be supported by the record or by findings reasonably amendable to judicial review. Not every verdict which raises a judicial eyebrow should shock the judicial conscience. Although the defendant has asked throughout the motion for a remediature of the various awards, it also posits the remediature is not possible in this case because the awards are so arbitrary that they cannot be used as a reliable measure for remediature. Based on that concession and the absence of any evidence or understandable methodology presented by defendant as to what it contends the verdict amount should have been, the court should decline any remediature. Pleading requirements. Defendant repeats its frequent erroneous lack of pleading assertion, this time contending that intent to harm was not pled in regard to the claim for the punitive damages. This again ignores that a complaint as a pleading is merely a tentative outline of the position which the pleader takes before his case is fully developed on the facts through discovery and evidence. The punitive damages pleading requirements are found in section 768.72(1) Florida statutes. The damages limitation provisions, including the intent to harm element, are in section 768.73 Florida statutes. Defendant conflates these separate requirements. Defendant demonstrably was not surprised that intent to harm was part of the plaintiff's case and that a question about it was coming in the second phase of the bifurcated punitive damages proceeding. Dr. Newberger testified that defendant's personnel intended to harm the Kowalskis, a point defendant complains about in the motion, pages 41 to 42. Defendant concedes that there are limitations on the types of conduct that will obtain immunity under Chapter 31. Motion 30, the defendant is not maintaining the statutory immunity would give a free pass to torture a child or place a child in a dungeon. Defendant just disagrees with where the court drew the line. The court crafted a thoughtful omnibus order concerning Chapter 39 immunity relatively early in the case. The court applied the standard the causes of action that survived beyond the court's application of Chapter 39 immunity were those that could not be considered to have been authorized or required by Chapter 39. Those included false imprisonment, battery, medical malpractice, negligent training, fraud, and intentional infliction of emotional distress. For each of these claims, the defendant cannot and has never been able to point to anything in Chapter 39, the Dependency Court's orders or DCF's directives, to authorize or require its actions. To take a couple of examples. 1. At no time did DCF or the Dependency Court authorize Maya's false imprisonment. Okay, Maya's false imprisonment. Between October 7th and the 13th. And neither could the defendant justify its conduct through Chapter 39, which expressly prohibits a hospital from detaining a child beyond 24 hours absent of a court order, which it did not have. Similarly, a hospital or any sheltering institution cannot batter a child, and it is absurd to suggest that the battery of a child is or was authorized by the Florida legislature or the Dependency Court. And 3, the sheltering hospital is not free to commit medical malpractice on a child simply because it has been entrusted with the child's care and custody by the Dependency Court. None of these causes of action and none of the claims that went to the jury are authorized or required under Chapter 39. Moreover, defendant cannot point to the manifest weight of the evidence to suggest otherwise. Having made this determination for each of plaintiff's causes of action, whether the particular actions were subject to Chapter 39's immunity, the court then conducted the trial by carefully excising from the evidence any avoidable mention of Dependency Court proceedings, DCF actions, and child abuse reporting. Child abuse reporting. At defendant's urging, the court read the jury a 10-page instruction detailing the visitation rights of the Kowalski family and the rights and duties of the defendant hospital under the various orders entered by the Dependency Court. The court gave this instructions to the jury in hard copy for its deliberations. Plaintiff objected to the instruction on multiple occasions for its deliberations. Based on the plaintiff's perception that the detailed instructions gave the defense exactly what it wanted, a basis to argue that its actions were all immunized. Notably, and favoring the defendant, the court kept away from the jury that defense counsel in this case had participated heavily in persuading the Dependency Court to enter the various orders and impose future restrictions on the Kowalski family. Orders and restrictions defendant sought to use as a child in this case. In short, the defendant had every potential benefit of Chapter 39 and its immunity provision, and the jury was repeatedly instructed that Johns Hopkins All Children's Hospital had absolute immunity for its reporting of suspected child abuse on October 7th and October 9th of 2016. The court did not err in allowing the plaintiff's attorney to use the per hour per component closing argument, motion 35. Florida does not have a defined method for calculating non-economic damages. As the 5th District stated, the Florida Supreme Court has acknowledged the difficulty in measuring non-economic damages as there is no mathematical or technical measure for them. In quashing the 2nd District's decision and noting that the verdict does not appear to be against the manifest weight of the evidence, the Supreme Court stated, obviously, in a personal injury action where damages are awarded, the injured party is entitled to fair and just compensation for the injuries sustained. However, it is not always absolutely possible to determine with complete assurance what may constitute full compensation. Each case must be considered on its own facts, since in most instances there is an element of speculation without the exactitude of a measuring yardstick. Argument of a plaintiff's counsel to the jury regarding various elements of damages, especially where pain and suffering are involved, based on a mathematical formula of calculable value or on per diem basis, may be helpful to the jury in its final deliberations. In summary, there is no support in Florida case law for prohibiting a daily, hourly, or other mathematical calculation that is understandable and supported by the evidence. Moreover, importantly, defendant did not suggest a different hourly rate or offer an alternative methodology for calculating damages. The defense counsel told the jury to use your common sense and suggested a tune-up for Maya on physical therapy at a cost of $15,000 for 1 year and psychotherapy at a cost of $200,000 or $250,000. There was no evidence, expert testimony, or otherwise offered to support this. Likewise, on the wrongful death claim for Beata, defense counsel offered no methodology, but simply suggested a range of $500,000 to $1 million or $1.5 million, even per person, would be something that would be fair and adequate. Overall, defense counsel said, and in terms of totals for this, $3 million, $4 million, I think that would be more than fair. These suggestions, unsupported by any evidence, gave the jury no guidance at all to a range for the multiple categories of damages itemized on the verdict form. The defendant's failure to offer an understandable alternative damages methodology, and akin to the Supreme Court statement, it is difficult for a party to challenge an award as excessive after the fact when the party declined to offer any guidance to the jury at trial. When the defendant does not assist the jury in establishing a range of verdict, it is more difficult for the defendant to later suggest that a verdict below the plaintiff's request is somehow a verdict which exceeds the maximum limit of the responsible range in which the jury was free to operate. The decision to grant defendant's motion for directed verdict on the negligent training claim at the end of the trial caused no confusion. Defendant admitted the evidence was relevant to the punitive damages claim. Okay, we're not even halfway through, but anybody? Hi Jen Grill, hi 61. I don't know. I went live like 12. I don't even know how many. I did one whole live where I did it. Nobody was there because it didn't go live on. It went registered, but it was like showing as upcoming, and they were just showing as upcoming when I thought I was live. And that happened, I don't know how many times today, 7 times. And so then I did the Adelson video, but I had to do that on the spur of the moment too, because that was one that was supposed to be done this afternoon. And then this one, I had to push this one through without any notification or anything like that. And I don't know if it's, because I know people do want to hear this, but I feel like maybe everyone here doesn't want to hear this now. So I don't know what to do. Should I just stop reading it now? So I'm not sure. And I don't even know if it's still, my guess is that it's not pushing out. Well, I know today with all the things, but I probably, if somebody searches take care of Maya trial, this video won't pop up. So I don't know, but maybe I'm just gonna stop and do something else. Thank you, Ruff. Thank you, appreciate that. So we can, I don't know, do something else, I guess, or maybe. Don Adelson was in court today. We discussed that before. And she was like very arrogant and trying to take control over everything, as she does. Hey, thank you, Ruff. Appreciate that. Thank you very much. Highlander, tomorrow is Tuesday. I do want to get a watercolor video done. I do want to have some time to do that. It's just, oh my gosh, there's so much to be done. I haven't done any of my Christmas stuff. Still trying to get stuff out in the mail. So maybe we'll just stop here for tonight, and I'll have to announce a video and probably promote it myself, because I'm just going to take a look to see if it's pushing out the video or not. I'm just going to just take a look. It's by doing a search. Nope. Nope. Not at all. Now let's see if I search with say today. Okay, if I do today, then we're number 3. If I don't search today, we end up way down. I mean, I don't even see it. I may try another search criteria. Say this week. This week, we come up number 3. And then another video is number 4 or 5. Let me see if I hit this month. No, we're down there. I don't know. Well, we'll see. We'll just keep going. Hey, little lady, how are you? I see you on, just made a comment on the Adelson video. Hi. Let's see. So let's see. I'm going to check some other stuff out just to see what people are saying about this, okay? Let me see here. So remember that Friday they're having a hearing, and let's see here. Let's see. Here's the filings. Let's see what they're saying about them. The state, they state that not a single defense witness definitively testified that Maya did not have CRPS. Oh, that's BS. This person is saying that is BS. I saw the guy on the stand, the doctor, saying that Dr. Crane, who is an actual expert in CRPS, unlike the plaintiff's doctors, did just that, and with medical certainty. The recent post about JC not letting IV ketamine evidence in because he gives an inch and they take a mile, I often wonder if he sees the very issue in the plaintiff. Someone said, I'm dumbfounded how anyone could seriously cite a missing dress and enticing with chocolate cake as acts so abhorrently so to justify a $261 million verdict. And now they're saying Maya was dragged after she defecated on herself. Dragged. Okay, so they're just saying this keeps getting worse and worse. They started off their response with their cringe catchphrase of they still just don't get it. Also, they're trying to insinuate again that Kathy was being perverted in taking the photos. And I'm sorry, but that's such a slap in the face to the victims of that actual behavior. It is. They feel like since they got this verdict they wanted, they can now claim whatever the F they want, and it's suddenly true. This is unreal. Let's see. you have to realize what that lawyer has such a vested interest in this verdict being upheld. And if they're part of that, they're cut of that, okay? And did the jury are they getting some? I mean, there are questions to ask. There are friendships there there are real questions there to ask. That's an incredible amount of money, and even $1 million to each juror is like nothing for them. I'm not saying that they did that. I'm talking about hypothetically what could be. Okay, so someone said, I don't know if I can continue to say this, but the outrageous lies in this document are just over the top. All the bullet points have zero corroborating evidence, but instead they're based solely on the allegations made by the plaintiffs. I would love to see just one piece of actual evidence that supports the defamatory claims made against the hospital. It is disgusting that millions of dollars can be awarded based on hearsay alone. Sickening. I also found it unfortunately amusing that the plaintiffs say that the hospital hid behind DCF and was just following orders. Sounds awfully familiar. Isn't that the case supporter's favorite line? Beata wasn't abusing her daughter. She was just following orders. Catch 22. The response is ridiculous. Somebody said, well, this plaintiff response is packed full of hyperbole and outright lies. Johns Hopkins was non-negligent. CRPS wasn't changed in the first week. Seriously, Anderson? Multiple doctors had doubts of the diagnosis regardless of the quack saying she did. Ugh. Then Beata's show she didn't want to AMA discharge. The actual evidence, not your phony argument, and Johns Hopkins didn't refuse transfer. The patients did the refusing. Please give timestamp of video evidence of Maya defecated. Not plaintiffs made up story to the jury. Now it's a white Christmas dress, not red, which Maya got with pic evidence. A birthday card was given to Maya. Defense has evidence of that as well. I'm just so disgusted with all the inflammatory language and outright lies. It's sickening. Someone said first it was a red dress, but then there was testimony and evidence to account for that and to make that complaint seem petty. Then Anderson tried to trick Beatty into accounting for a blue dress that had never been mentioned before. Now we suddenly have a mystery white dress. It's like the Sleeping Beauty fairy godmother of dresses. It shifts colors according to Anderson's will. Okay, let's see here. So they say that the judge's bias destroyed the defense's case. Day 21 of the trial, you can go to 840. The reality is Maya and Jack already testified that she had ketamine at home orally, and I'm not seeing the huge prejudice here that you seem to be suggesting, that if we don't show it was done via an infusion versus orally, that somehow makes or breaks the case. Hunter's disbelief is palpable. And someone said that discussion really struck me too when it took place. To me, it consolidated my thinking that Judge Carroll did not understand the nuances of this case. Prior to that discussion, he made comments that demonstrated a belief in the plaintiff's account that Maya had dystonia, couldn't walk, at the hospital thought she was lying, that Beata had a right to doctor shop and administer ketamine to Maya, how she was, etc. I also think that was due to Carol accepting the apparent opinion of Dr. Duncan that Maya had CRPS, and then Munchausen's by proxy was not possible, as it was an either or. I also think that he didn't understand that the hospital could say that Munchausen's by proxy was relevant as a child is assessed with the context of the family system, and they were looking at Beata's behavior towards Maya too. I also think that he believed Kirkpatrick, Chopra, etc. were experts. Don't get me started. I also think that Judge Carroll should not have watched the Take Care of Maya Netflix doc beforehand. I recall it being stipulated that he did need to watch it. I can't recall why. But whoever made that documentary needs a share of the winnings, as they did a number on the viewers. It was incredibly emotive, and I'm loath to say incredibly well made, if it weren't for being so incredibly one-sided. Little did he know CRPS and conversion disorder are very often comorbid diagnoses. Someone said, I think you nailed it with Carol's inability to grasp nuance. He seemed to have no understanding of Munchausen's by proxy. He appeared to make no effort to entertain the possibility that Maya and JHACH may not have been truthful about ketamine only being given orally, essentially saying that JHACH and Maya said they didn't, so it must be true. What a joke. I said, wow, you learn something new every day on here. I didn't know he watched the documentary. That explains a lot to me now. I truly believe now that there's a lot more to this story than we might even know. He didn't want to hear about the IV ketamine. He didn't want to read too many emails. He didn't want to see too many photos. He didn't want to hear about standards of care. He didn't want to hear about MSP unless it was from the plaintiff. He may as well have worn noise-canceling headphones for the defense's case. Oh, wait. No, then he couldn't have heard all those objections he needed to overcome. He obviously didn't want to hear about the IV ketamine versus listening to the argument. He just resigned to, nope, not going there. When he made these rulings, he seemed to always think that the defense was doing something with another intention, that if he allowed this, then they would trick him into something else. I've never seen a judge so protective of one party. I get trying to be sensitive, but he went so over the top that he didn't allow facts in. It's like he was overcorrecting so badly, thinking the defense was trying to pull the wool over his eyes. He allowed the plaintiff to say what they wanted without allowing the defense to defend. Okay. Sarasota County Sheriff's investigative narrative. Did we go over this? Let me see. DCF. I think we did, didn't we? I think so. Where is the... Hold on a minute, they're saying so. Hang on a minute. Page 10 and 11. Okay, here's something from Beata's Kowalski's co-worker at Quorum CVS Pharmacy, James Schott, testified that he wrote "patient is terminally ill" on Dr. Kirkpatrick's prescription following a telephone conversation with Dr. Kirkpatrick. Well, remember her email said something about that to him? Mr. Schott claimed the terminally ill designation was at the direction of the physician. For his part, Dr. Kirkpatrick relates a different story. Dr. Kirkpatrick denied giving Mr. Schott permission to place terminally ill on the diluted prescription because this was outside my scope. Dr. Kirkpatrick claimed this was inconsistent. 5 days after the terminally ill prescription above, on November 10, 2015, Mrs. Kowalski contacted another CVS pharmacist colleague, Jocelyn Krager, and requested that the term terminal be placed on another home infusion prescription for Dr. Kirkpatrick's signature. After Ms. Krager emailed Dr. Kirkpatrick for permission to place a terminal designation, Dr. Kirkpatrick responded via email to Mrs. Kowalski and said he was not willing to write a terminal prescription because this was outside the scope of his practice. Dr. Kirkpatrick suggested Mrs. Kowalski contact your local hospice care unit and determine if they have a palliative care program. Conclusion. In October of 2016, Maya Kowalski presented to JHACH dangerously underweight and malnourished with an implanted port and a mother who demanded dangerously high ketamine infusions but refused to produce Maya's medical records from other providers. As it turns out, ample evidence suggested that Beata Kowalski was administering intravenous ketamine through Maya's port in direct violation of the prescribing physician's orders. It is apparent that Beata Kowalski's infusion of ketamine through Maya's port was part of an overall escalation in Maya's ketamine treatment that culminated in the hospitalization at issue in this case. Okay. Let's see what else we have. That's very interesting, isn't it? Judge messed up big time on this. From that timeline, I'm reading this as Maya had just had a high ketamine dose either that day or the day before. Surely, even if it was legitimate, even those doing high-dose ketamine and ketamine comas would do it immediately following a high dose within 48 hours, right? I'm wondering, were all these documents available to the jury? Was any of this evidence they should have reviewed? It's abundantly clear that Beata was at the center of a criminal child abuse inquiry and that the police were circling in on her. She did a lot of things that were pretty easily proven, regardless of Maya's diagnosis. Even if it didn't amount to actual criminal charges, it might have been referred for professional discipline as a nurse. Her husband was willing to divorce her to get Maya home. How anyone can claim Beata was cleared or that she would take her own life to help Maya is beyond me. Someone observed a video clip posted of Maya when she was in a coma in Mexico. It is redacted, but seems clear it's Maya being referred to. No one else in this case was out in a coma, to my knowledge. Okay. Dr. Alexander. Let's see. Why can't I? Okay, this is from Brandon Alexander, deposition August 21st, 2020. Today, she was performing infusions at home before she came in to see you. Alexander says, I believe one of my notes states what I was told about her ketamine. Let me see if I can find it. Maybe this is, here we go. So I am on APH 50, which is part of my notes or part of staff note under that hospital course, which would include my history that I obtained about halfway through. She has been doing ketamine booster treatments every few weeks. That has been done with Dr. Hannah. The pain still continues to return several weeks post-ketamine booster therapy. Mother states that she has been doing ketamine injections through the patient's port at home of 50 milligrams up to 30 minutes PRN. The mother states the patient will occasionally go days without needing ketamine, but sometimes she needs it multiple times a day. That's what I have that was relayed to me by the mother. Crazy. Let's see. The doctor was very firm about his accuracy on documenting this. It's too bad this evidence was excluded. Okay, thanks for posting this. It's important to emphasize that it wasn't just a matter of someone seeing IV ketamine prescribed and assuming it was given that way, but rather the doctor actually learning and documenting that the ketamine was being given via the port. Beata talked about giving IV fluids and drawing blood for labs in her own emails, so we already knew she was doing stuff that she shouldn't have been with the port. Okay, before someone says it didn't happen, Dr. Hannah also made Beata sign a contract that she won't do it again, where he would stop prescribing ketamine. Even the guy who was comfortable ramping up the dose to an insane amount and giving it without monitoring blood pressure was not comfortable with this. Yeah, I finally saw the document. There were a lot of claims that this is just standard procedure, but the note wasn't signed until October. Interesting and sad. I also find it frustrating to see the people who saved Maya's life, and I firmly believe this to be the case, vilified by so many. I wish her mother could have accepted the help she needed herself, though with a better ending. But I'm amazed Maya is still functioning okay, considering the levels of drugs put into her. I think this is evidence that Beata was not just following doctor's orders. This is one of the plaintiffs and Kowalski's supporters' main assertions. This should have been admissible to refute that claim. Thank you for posting. So frustrating the judge wouldn't let this in. So with Kathy Beatty's voice on the phone, even though that there was written evidence that it was not Catherine Beatty, the judge let the plaintiffs introduce it as if it was, and then let the jury decide with the Christmas dress and the photos. Despite email evidence about them, the judge let the plaintiffs enter their version and then let the jury decide. But with this couldn't be entered in to let the jury decide. Why not? This is contemporaneous evidence, unlike what the plaintiff did. It doesn't make sense to me to run a trial like this. I must add, not that I think this jury would care at all. The jury felt sorry for the Kowalskis and just threw money at them. I don't think there was anything the defense could have done or said, or anything that they could have proven about Beata that would have changed their mind. So Maya perjured herself on the stand under oath when stating her mother never gave her IV ketamine at home. Total sick girl she is. I believe Maya probably doesn't even remember a whole heck of a lot from that year and a half period when she was drugged and hallucinating. I think, though, maybe Beata told her repeatedly to never ever tell anyone about this, and Maya has complied. I would suggest to take what Maya says with a grain of salt. Consider the case that is pretty clear not true when she stated that Beatty's voice was on that recording. We know it wasn't, and she stated that she didn't curse. 2 quick examples, and then consider her motive to twist the truth. Consider what makes the most sense to have happened. Think of all the things we know the plaintiffs have claimed that are not true. They didn't know Sally Smith was with CPS when Beata's email clearly states she knew. The claim about the dress, the claims about not allowing her to practice her religion, and on and on. And then consider the number of people choosing to disregard what's right in front of them. I'm trying to think. I remember walking around the lake and we were discussing this, and maybe I was listening to some kind of a podcast or something. Can I remember something? Oh, let's see. Someone said, she was a 10-year-old girl being massively sedated. I think it's entirely possible she has no clear memories from that time and can be told what happened and assume her memory is correct. I don't like calling her a liar about that time. She's still a child, and she was abused, sedated child then. She probably believes that her mother never did that, because I don't think she's yet accepted what her mother did, allegedly. I agree, and now her dad is gaslighting her and Anderson for more money, hence an essay allegation that likely did not happen. Essay allegation now? Oh boy. Oh boy. Okay. Okay, let's see. See what's going on. I'm going to go back to the legend. Okay. So anyway, yeah, I don't know. Let me check some other stuff here out. Okay, let's look at something else. We're going to switch gears. We're going to move real quick to Gabby Petito. We are going to let's see. Joseph Petito and Nichole Schmidt. Plaintiffs versus Christopher Laundrie and Roberta Laundrie. Defendants. This is the third amended complaint. Come now, Joseph Petito and Nichole Schmidt, by and through their undersigned counsel, and file that within third amended complaint against the defendants, Christopher Laundrie, Roberta Laundrie, and Steven Bertolino. And in support thereof, allege as follows. 1. This is an action for damages that exceed $30,000, exclusive of prejudgment interest costs and attorney's fees. 2. The venue is proper in Sarasota County, Florida, because the defendants, Christopher Laundrie and Roberta Laundrie, reside therein. 3. The court has jurisdiction over the within matter pursuant to FS 26.012. 4. The plaintiff, Joseph Petito, is a resident of Vero Beach, Florida, and is the father of Gabrielle Petito, deceased. Plaintiff Nichole Schmidt is a resident of Seffner, check this, Florida, and is the mother of Gabrielle Petito, deceased. 6. Defendants Christopher Laundrie and Roberta Laundrie are residents of Northport, Florida, and the parents of Brian Laundrie, deceased. The defendant, Steven Bertolino, is a resident of the state of New York and is a lawyer licensed to practice law in New York. The court has personal jurisdiction over him pursuant to FS blah, 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 blah. At all times relevant to the within cause of action, Steven Bertolino was acting as the agent for Christopher Laundrie and Roberta Laundrie when they resided in Florida. Brian Laundrie and Gabrielle Petito became engaged to marry on or about July 2nd, 2020. On July 2nd, 2021, Brian Laundrie and Gabrielle Petito left New York in a van owned by Gabrielle Petito to take a trip to the western United States, which was expected to last for several months. Prior to the trip taken by Gabrielle Petito and Brian Laundrie, Joseph Petito and Nichole Schmidt and Christopher Laundrie and Roberta Laundrie had a cordial relationship. Gabrielle Petito had hopes of becoming a travel influencer, a van lifer, and document her cross-country travels on social media sites such as YouTube, Instagram, and TikTok. During the course of the aforementioned trip, Gabrielle Petito called her family almost daily, including her parents, Joseph Petito and Nichole Schmidt, and her siblings. The last communication that Gabrielle Petito had with Joseph Petito was on August 21st of 2021. The last communication that Nichole Schmidt had with Gabrielle Petito was on August 27th of 2021. It is believed that on August 27th of 2021, Brian Laundrie murdered Gabrielle Petito. The cause of her death was blunt force injuries to the head and neck with manual strangulation. Gabrielle Petito was 22 years of age at the time of her death, and after Brian Laundrie murdered Gabrielle Petito, Brian Laundrie sent text messages back and forth between his cell phone and Gabrielle's cell phone in an effort to hide the fact that she was deceased. On August 27, 2021, it's believed that Brian Laundrie sent a text to Nichole Schmidt in which he referred to Gabrielle's grandfather, Stan, by name. Gabrielle never called her grandfather by that name. You remember we knew that when that was happening in real time just about, right? On August, and I've always wondered about that trip when he went back to help his father with that storage unit. What happened that week? That's what I want to know. On August 29, 2021, Brian Laundrie advised his parents, Christopher Laundrie and Roberta Laundrie, in a frantic telephone call that Gabby was gone and he needed a lawyer. On August 29, 2021, Christopher Laundrie and Roberta Laundrie spoke with Steven Bertolino, advising him that Gabrielle was gone, that Brian Laundrie needed a lawyer, and sent him a retainer on September 2nd of 2021. On September 2nd, 2021, on behalf of Brian Laundrie, Steven Bertolino entered into a fee agreement with Fleener Peterson LLC, a criminal defense law firm located in Laramie, Wyoming, for the purposes of representing Brian Laundrie. Prior to the time The Fleener Peterson LLC was retained. Steven Bertolino contacted other attorneys in Wyoming to represent Brian Laundrie, including a public defender's office in this same county where Gabby Petito's body was ultimately discovered. On August 30th, 2021, Brian Laundrie sent a text message from Gabby Petito's cell phone to Nichole Schmidt stating that there was no service in Yosemite in an effort to deceive Nichole Schmidt into believing that Gabby Petito was still alive. On September 1st, 2021, Brian Laundrie returned to the home of his parents, Christopher Laundrie and Roberta Laundrie, driving Gabby Petito's van. After this point in time, there was no contact between Joseph Petito and Nichole Schmidt on the one hand, and Christopher Laundrie and Roberta on the other. From September 10th, 2021, check with client, until September 19th, 2021, when Gabrielle's remains were found at the Spread Creek dispersed campground area in Wyoming, the plaintiffs were extremely distraught and were attempting to locate Gabrielle. While Gabby Petito's family was suffering, the Laundrie family went on a vacation to Fort DeSoto Park on September 6th and 7th of 2021. They went on vacation knowing that Brian Laundrie had murdered Gabby Petito. It is believed that they knew where her body was located and further knew that Gabby Petito's parents were attempting to locate her. In an effort to avoid any contact with Nichole Schmidt on or about September 10th, 2021, Roberta Laundrie blocked Nichole Schmidt on her cell phone such that neither phone calls nor texts could be delivered, and she blocked her on Facebook. On September 13th of 2021, the date Brian Laundrie left his home, according to a televised interview with Steven Bertolino on or about October 23rd, 2021, Brian Laundrie was grieving. According to the Cambridge English Dictionary, grieving is defined as feeling sad because someone has died. On September 14, 2021, with full knowledge that Gabby Petito had been murdered by Brian Laundrie, and it is believed that they knew the whereabouts of her body, Steven Bertolino, on behalf of Christopher Laundrie and Roberta Laundrie, issued the following statement. This is understandably an extremely difficult time for both the Petito family and the Laundrie family. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. On the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. For the Laundries and Steven Bertolino to express their hope that Gabby Petito was located and reunited with her family at a time when they knew she had been murdered by Brian Laundrie was beyond outrageous. Steven Bertolino, at the time he issued the September 14, 2021 statement, was aware that Joseph Petito resided in Florida, and the statement was intended to reach Joseph Petito. The September 14, 2021 statement released by Attorney Bertolino was intended to be disseminated nationwide and was broadcast in news reports in Florida and nationwide and was disseminated electronically into Florida. The October 23, 2021 interview was conducted by a reporter with WABC Channel 7 in Sarasota. At all times relevant to the within cause of action, Steven Bertolino had sufficient minimal contacts with the state of Florida in that he was acting as an agent for Christopher Laundrie and Roberta Laundrie, who are residents of the state of Florida, and he released numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and or Brian Laundrie to the national press and into Florida in particular. At all times relevant to the within case of action, Steven Bertolino engaged in substantial and not isolated activity in the state of Florida, which was continuous and systematic. On September 16, 2021, attorney Richard Stafford, on behalf of Gabby Petito's family, issued a letter to Christopher Laundrie and Roberta Laundrie as follows. We are writing this letter to ask for your help to find our beautiful daughter. We understand you are going through a difficult time and your instinct to protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat, and our lives are falling apart. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How could you keep her location hidden? You were both at Jim and Nichole's house. You were so happy that Brian and Gabby got engaged and were planning to spend the rest of their lives together. Please, if you or your family has any decency left, please tell us where Gabby is located. Tell us if we're even looking in the right place. All we want is Gabby to come home. Please help us make that happen. Despite the fact that the defendants knew Gabby Petito was deceased, they knew where her body was located and expressed their hope that Gabby would be reunited with the family. Christopher Laundrie and Roberta Laundrie and Steven Bertolino refused to respond to either Joseph Petito or Nichole Schmidt. While Joseph Petito and Nichole Schmidt were desperately searching for information concerning their daughter, Christopher Laundrie, Roberta Laundrie, and Steven Bertolino were keeping their whereabouts of Brian Laundrie secret. Gabby Petito's remains were discovered on September 19th in Bridger-Teton National Forest in Wyoming. On that same day, Steven Bertolino issued a statement saying, "The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family." Christopher Laundrie, Roberta Laundrie, and Steven Bertolino knew of the mental suffering and anguish of Joseph Petito and Nichole Schmidt in not knowing the well-being or location of their daughter, and further knew that such mental suffering and anguish increased each day that Gabby Petito was missing. While Christopher Laundrie, Roberta Laundrie, and Steven Bertolino remained silent about Gabby Petito's death at the hands of Brian Laundrie and the location of her body, all the while knowing that she was deceased and knowing the proximate location of her body, they chose to issue statements on September 14th, 2021 and September 19th, 2021. In issuing the statements, Christopher Laundrie, Roberta Laundrie, and Steven Bertolino engaged in conduct which was intentional or reckless, and they knew or should have known that their statements would cause emotional distress, and knew or should have known that Joseph Petito and Nichole Schmidt would likely suffer emotional distress from the statements. Christopher Laundrie, Roberta Laundrie, and Steven Bertolino exhibited conduct that was outrageous and went beyond all bounds of decency and is regarded as odious and utterly intolerable in a civilized community, in that they remained silent concerning Gabby Petito's death and the location of her body, but then made statements giving hope to Joseph Petito and Nichole Schmidt that Gabby Petito was still alive, and expressed it was a difficult time for the Laundrie family knowing their son had murdered Gabby Petito. Count 1. Joseph Petito versus Christopher Laundrie. Joseph Petito hereby restates and incorporates paragraphs 1 through 40 above as though fully set forth herein. As a direct and proximate result of the intentional or reckless conduct of Christopher Laundrie, plaintiff, Joseph Petito has been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for the enjoyment of life experienced in the past and to be experienced in the future, which emotional distress was severe. Wherefore, plaintiff Joseph Petito respectfully requests this honorable court enter judgment in his favor and against the defendant Christopher Laundrie, and award to him just compensation for the damages he has suffered, together with costs and such other relief as this honorable court deems just and appropriate. Count 2. Joseph Petito versus Roberta Laundrie. Joseph Petito hereby restates and incorporates paragraphs 1 through 40 above as though fully set forth herein as a direct and proximate result of the intentional or reckless conduct of Roberta Laundrie. Plaintiff Joseph Petito has been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for the enjoyment of life experienced in the past and to be experienced in the future, which emotional distress was severe. Wherefore, the plaintiff Joseph Petito respectfully requests this honorable court enter a judgment in his favor and against the defendant, Roberta Laundrie, and award to him just compensation for the damages he has suffered, together with costs and such other relief as this honorable court deems just and appropriate. Count 3. Joseph Petito versus Steven Bertolino. Joseph Petito hereby restates and incorporates paragraphs 1 through 40 above as a direct and proximate result of the intentional or reckless conduct of Steven Bertolino. Plaintiff Joseph Petito has been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for the enjoyment of life in the past and to be experienced in the future, with emotional distress, which emotional distress was severe. Wherefore, Plaintiff Joseph Petito respectfully requests this honorable court to enter a judgment in his favor and against the defendant, Steven Bertolino, and award to him just compensation for the damages he has suffered, together with costs and such other relief as this honorable court deems just and appropriate. Count 4. Nichole Schmidt versus Christopher Laundrie. Nichole Schmidt hereby restates and incorporates paragraphs 1 through 4 above as though fully set forth herein. Okay, so this is going to go through the same thing that Joseph's were. So it's count 4 for Nichole Schmidt versus Christopher Laundrie, count 5 Nichole Schmidt versus Roberta Laundrie, and count 6 Nichole Schmidt versus Steven Bertolino. So that's the amended complaint there for the Petitos. And we also have an answer here from the defendants. So hang on, let me get this. Wow, it's a busy. Comes now the defendant, Steven Bertolino, Mr. Bertolino, through his counsel pursuant to this court on November 29, 2023, order granting plaintiffs motion for leave to file third amended complaint and the Florida Rules of Civil Procedure, and hereby files his answer and affirmative defenses to the plaintiff's third amended complaint filed on November 30th, and states as follows. Answer. This defendant admits plaintiffs have brought the instant action and allege that plaintiff's damages exceed $30,000 for jurisdictional purposes only. The remainder of paragraph 1 of plaintiff's third amended complaint is denied. The defendant admits the allegations contained in paragraph 2 of the plaintiff's third amended complaint. The defendant admits the allegations contained in paragraph 3 of plaintiff's third amended complaint for jurisdictional purposes only. Upon information and belief, this defendant admits the allegations contained in the paragraph 4 of plaintiff's third amended complaint. Upon information and belief, the defendant admits plaintiff Nichole Schmidt is the mother of Gabby Petito, deceased. The defendant is without knowledge as to the remainder of the allegations contained in paragraph 5 of plaintiff's third amended complaint, and therefore denies same. The defendant admits the allegations contained in paragraph 6 of the plaintiff's third amended complaint. The defendant admits the allegations contained in paragraph 7 of plaintiff's third amended complaint. With respect to the allegations contained in paragraph 8 of plaintiff's third amended complaint, the defendant admits he acted as an attorney and therefore agent for defendants Christopher Laundrie and Roberta Laundrie when the statements described in the third amended complaint were issued on their behalf. With respect to the allegations contained in paragraph 9 of plaintiff's third amended complaint, upon information and belief, this defendant admits that Brian Laundrie and Gabby Petito became engaged. With respect to allegations contained in paragraph 10 of plaintiff's third amended complaint, upon information and belief, the defendant admits Brian Laundrie and Gabby Petito set out on a trip together in the summer of 2021. With respect to allegations contained in paragraph 11 of plaintiff's third amended complaint, upon information and belief, this defendant admits that prior to the trip taken by Gabby Petito and Brian Laundrie in the summer of 2021, Nichole Schmidt had briefly met Christopher Laundrie and Roberta Laundrie on a singular occasion in front of Ms. Schmidt's home in New York. This defendant is without knowledge as to the remainder of the allegations contained in paragraph 11 of plaintiff's third amended complaint and therefore denies same. 12. The defendant is without knowledge as to the allegations contained in paragraph 12 of plaintiff's third amended complaint and therefore denies same. 13. The defendant is without knowledge as to the allegations contained in paragraph 13 of plaintiff's third amended complaint and therefore denies same. 14. The defendant is without knowledge as to the allegations contained in paragraph 14 of plaintiff's third amended complaint and therefore denies the same. The defendant is without knowledge as to the allegations contained in paragraph 15. The defendant is without knowledge. Okay, you're without knowledge. That's a given, Mr. Bertolino. Thank you for admitting that. Okay, the defendant is either without knowledge and or is unable to admit or deny knowledge as to the allegations contained in paragraph 16 of the plaintiff's third amended complaint, as to do so would violate the attorney-client privilege between this defendant and by Brian Laundrie, which Brian Laundrie has not waived, and therefore this defendant denies same. Upon information and belief, this defendant admits the allegations contained in paragraph 17 of plaintiff's third amended complaint. The defendant is either without knowledge or is unable to admit or deny knowledge, as it would violate the attorney-client privilege, blah, 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 blah. The defendant is either without knowledge. Okay, so he's doing this again. We're just, Mr. Bertolino, we're just so tired of this, Mr. Bertolino. So he's going to continue this. With respect to the allegations contained in paragraph 27 of the plaintiff's third amended complaint, upon information and belief, the defendant admits the defendants Christopher Laundrie and Roberta Laundrie went to Fort DeSoto Park with Brian Laundrie on September 6th to September 7th. The defendant is without knowledge as to the allegations contained in paragraph 28. Okay, and with respect to the allegations contained in paragraph 29 of plaintiff's third amended complaint, this defendant admits he described Brian Laundrie as grieving during a televised interview that occurred in October of 2021. With respect to the allegations contained in paragraph 30 of the plaintiff's third amended complaint, the defendant admits he released a statement on behalf of his clients, defendant Christopher Laundrie and Roberta Laundrie, on September 14th, which is cited in paragraph 30. The statement was made following urging and demands, some life-threatening, for information and comment from the plaintiffs, law enforcement, the press, and the public. The defendant denies the defendants Christopher Laundrie and Roberta Laundrie had full knowledge that Gabby Petito had been murdered by Brian Laundrie at the time, and further denies that the defendants Christopher Laundrie and Roberta Laundrie knew the whereabouts of her body. The defendant denies the allegations set forth in paragraph 31 of plaintiff's third amendment complaint as phrased. With respect to the allegations contained in paragraph 32 of the third amended complaint, upon information and belief, the defendant admits that on September 14th, plaintiff Joseph Petito resided in Florida. The September 14th, 2021 statement was not intended to reach Joseph Petito. Rather, the purpose of the statement was to provide a public response to the escalating pressure from the plaintiffs, law enforcement, the press. Well, hey, if it was meant to provide a public response to escalating pressure from the plaintiffs, and the plaintiff is Joseph Petito, then how, Mr. Bertolino, can you say it was not intended to reach Joseph Petito if you just said the purpose of the statement was to provide a public response to escalating pressure from the plaintiffs? That makes 0 sense, Mr. Bertolino, 0 sense. Law enforcement, the press, and the public, who were all demanding the defendants Christopher Laundrie and Roberta Laundrie provide information, comment, or other type of response to the events being reported worldwide and incessantly throughout each day during that time. As such, this defendant denies the remainder of the allegations contained in paragraph 32, the third amended complaint. With respect to allegations contained in paragraph 33, the defendant had no particular intention to disseminate the September 14th statement to any particular geographic location. That's a lie, Mr. Bertolino. You just said the purpose of that statement. The statement was intended for general public consumption in response to escalating pressure and demand, some life-threatening, there you go again, from the plaintiffs, law enforcement, the press, and the public. Oh my gosh. To the best of the defendant's recollection, the October 23, 2021 interview was not conducted by a reporter with WABC, Channel 7 in Sarasota. As such, paragraph 34 is denied. With respect to the allegations contained in paragraph 35 of the plaintiff's Third Amendment complaint, the defendant does not contest personal jurisdiction. Mr. Bertolino admits he was acting as an attorney and therefore an agent for the defendants, Christopher Laundrie and Roberta Laundrie, who are residents of the state of Florida. With the statements described in the third amended complaint were issued on their behalf. Mr. Bertolino also admits he made statements on behalf of defendants Christopher Laundrie and Roberta Laundrie from urging and demand, some life-threatening, from plaintiffs, law enforcement, the press, and the public. Mr. Bertolino denies the remainder of paragraph 35. With respect to the allegations contained in paragraph 36, defendant does not contest personal jurisdiction. With respect to the allegations in 37, he denies that this defendant admits the plaintiffs issued a statement through their attorney, Richard Stafford, on September 16th, and that statement, as set forth in the third amended complaint, appears to be the statement issued by Richard Stafford. The defendant denies that Mr. Stafford delivered that statement to the Laundrie family, either directly or through Mr. Bertolino. The defendant denies the allegations set forth in paragraph 38 of the plaintiff's Third Amendment complaint as phrased. The defendant denies the allegations set forth in paragraph 37. With respect to the allegations contained in paragraph 40 of plaintiff's Third Amendment complaint, the defendant admits that Gabby Petito's remains were discovered on September 19th in the Bridgerton-Teton National Forest in Wyoming. The defendant also admits that on the same day, he issued a statement on behalf of his clients, defendants Christopher Laundrie and Roberta Laundrie, and that the statement as set forth in the third amended complaint is the statement so issued by Mr. Bertolino. The statement was made following urging and demands, some life-threatening, from plaintiffs, the press, and the public. The defendant denies the allegations set forth in paragraph 41 of the plaintiff's third amended complaint. The defendant denies the allegations set forth in paragraph 42 of the third amended complaint, and the defendant denies the allegations set forth in paragraph 43 of the plaintiff's third amended complaint. Count 1, paragraphs 44 and 45, third amended complaint does not pertain directly to the defendant, and therefore he is without knowledge as to the allegations contained therein. And then so he's going to, so here, let's go where they have Steven Bertolino. With respect to the allegations contained in paragraph 48 of the plaintiff's third amended complaint, this defendant hereby restates and re-alleges his responses to paragraphs 1 through 40 as though fully set forth herein. The defendant denies the allegations set forth in paragraph 49 of the plaintiff's third amended complaint. And he's going to go through Nichole Schmidt. Demand for a jury trial. The defendant demands a trial by jury on all issues, so triable as right by jury. Affirmative defenses. The damages set forth in plaintiff's third amended complaint were caused by or contributed to by individuals or entities over which this defendant has no control. As such, this defendant is not liable, or alternatively only liable for his pro rata share of damages. Plaintiffs have failed to set forth a cause of action recognizable under Florida law. The deficiency with the plaintiff's cause of action include, but are not limited to, plaintiff's severe emotional distress was pre-existing prior to the alleged conduct of the defendant and as such is not actionable. Plaintiffs claims that this defendant failed to lessen or reduce their pre-existing emotional distress are not actionable. Plaintiffs have failed to allege facts demonstrating intentional or reckless conduct by this defendant. Plaintiffs have failed to identify how the alleged outrageous conduct by this defendant is a legal cause of their damages. This defendant did not make the alleged outrageous statements directly to the plaintiff or plaintiffs. They were not the targeted recipients of the statements. That's a lie. You said it over there, you lied. Plaintiffs' claims are barred because they are based upon statements that are protected by the litigation immunity privilege. Plaintiffs' claims against this defendant are barred based on the plaintiff's failure and inability to establish conduct on the part of this defendant that is outrageous enough as a matter of law to support such a claim. Plaintiffs' claims are barred because they are based upon the defendant's assertion of their legal rights in a legally permissible way. Plaintiffs' claims against the defendant fail on the basis that this defendant was acting within the course and scope of his agency relationship with his clients and the alleged wrongful statements were issued on behalf of this defendant's clients. Plaintiffs have not identified a sufficient statutory or contractual basis for recovery of attorney's fees claimed in plaintiff's third amended complaint, and therefore all such requests must be denied. This defendant adopts any and all affirmative defenses raised by any co-defendant in this matter, whether expressly mentioned herein or not, to the extent that they are applicable and consistent with Mr. Bertolino's interests. This defendant reserves the right to amend his affirmative defenses and allege affirmative defenses. Okay. So that's Mr. Bertolino's response. Wasn't me. And Mr. Bertolino. Okay, so on December 8th, Bertolino filed that response with the 12th Judicial Circuit Court in Sarasota, Florida, after Gabby's parents, Joseph and Nichole, claimed Bertolino knew that Gabby died and failed to inform them. Instead, according to the lawsuit, Bertolino gave them false hope that Gabby may still be alive. So we have that. And hey, Jeff H. Good to see you. How are you doing? How's it going? What you up to? What are you doing? What cases are you up to? You doing this Maya thing at all? You following this Maya case at all? Are ya? What are you up to? Bunch of trouble? I am going to open a new Zoom. If anybody wants to come up on the panel, come up on the panel. I may be doing a little bit of watercolor. Good. You've been on about you're still going on about the Idaho 4 right now, huh? There's not that much to discuss on that, is there? I mean, a lot of conspiracy stuff, a lot of Delphi. What about, did you follow the Maya trial at all? Miss you too. Okay, but I'm going to do something that's going to be different. It's not a crime. Let me just get out of here. I'm going to start up a new live. You're discussing the timeline. Okay. Gotcha. You don't know anything about that Maya trial? See, look at that. I'm back. And watch, I'm going to kick everybody out. And then I'm going to let everybody, let's see, copy invitation. You don't know anything about that. That's, I don't know. Did you watch the documentary? It is a biased documentary, you know that. Let me get to this. I had a bunch of issues with my OBS today, and I had about 16 aborted lives. So it's amazing that some people even found themselves here tonight, because mission aborted. Sharon's seeing red. She's really angry. Hello, Sharon.
There we go. Man, I could not get the sound to turn on. Second time today that's done it. Now I'm okay.
Hello, Ruff.
Hello, Ralph. Welcome back.
Welcome back.
Welcome back.
Hi, Jeff. You want to come up, Jeff? I'll send you a link. Come on up. We're going to do a little informal stuff. I'm going to try a little bit of watercolor.
Oh.
Why did she end? What's going on?
No, I didn't end.
Oh,
okay.
We're live.
Okay.
Yeah.
I'm like,
why does everybody get so excited?
Yes.
Okay, we're live and it's all good. I'm going to see if Jeff wants to come up. I'm going to send Jeff a link. We're going to have a little fun, just a little fun. Just Jeff is, it's not about, we don't have to talk about. You can watch. I'm going to try to do a watercolor thing.
Okay.
Let me see. I got to get my Gmail up here because everything, my computer's like restarted like 97 times today. Either from the,
Yeah.
okay.
What's a watercolor thing?
Painting.
Oh, okay.
Yeah, it's really relaxing. My daughter got me into a lot of it, and I mean, I've had the watercolors, but and I've watched it, and I've said, oh yeah, I want to do that. But I did the roses were pretty good that I did. Okay.
Oh, so we're gonna have an art class.
Well, no, I mean we can talk about anything, but
No, I want to see the watercolor thing.
no, I am going to sign in my phone so I can go over there. Let me see.
I need to do that where the painter comes and we paint pictures.
Jeff, you have like 3 emails here. I hope I sent it to the right one. Okay. And let me see something. Oh yeah, the painting thing. I know. Somebody told me recently they do that here. Someone that was in our chat.
That would be cool.
I bought one of One Eye Blind Art's pictures, and I'll
Get it
paint,
yet?
and I'll tell you,
You got it?
really cool in person. Yes,
I didn't get
Yes.
my thing. How did you get yours?
I don't know. It came today.
Oh,
Hi.
Hello.
Hello.
Which one did you get, Sharon?
Let me see if I can. I think it's over here. I'll be right back.
I like watercolor. It dries fast.
Yeah.
I get impatient with oil because it takes too long to dry. So that's why I like acrylic and watercolor. Dries
Oh, you
quick.
paint? You paint, Deborah?
Yep.
Oh man, I want to see some of your work.
Okay. I think I've shown something before that I did for was just well, I've shown stuff before and
oh wow.
I'm not sure.
anyway.
Cool.
There.
Oh, please.
Oh wow.
Whoops. Wait.
I love the colors.
Yeah.
There. Nelson. And it's signed on the back. It's nice, isn't it?
Yes, pretty colors.
It's very textured. I like it.
It's pretty.
It the pinks around the edges are much pinker. They're really beautiful pink all the way around the edges.
Mm.
And they blend in really well. I mean, he makes them blend
Mm-hmm.
like an ombre type thing. And they blend really well.
I want to get that one. Didn't he have one that was called Arizona or something? Mountain.
Oh no, he had
Was it
one pinker. I might get the other one too, and I put them side by side.
Okay.
Yeah.
Right.
I'm going to do something here.
This direction, maybe, or maybe in this direction. Maybe.
Wait, here's
Oh,
the-
somebody's in.
I gotta log in on my phone.
Got
do
my
this.
video.
Hi, Jeff.
Hey, everybody.
Hi. I can
Hey,
barely.
Jeff.
Hi, Jeff.
I'm gonna go and log on my phone. And what I did with my. Just had my watercolor the other watercolors the other day.
That's nice, Sharon.
The painting is, yeah, isn't it?
Yeah,
Yep.
it is.
Yep.
So how you doing, Jeff?
Good to see you all. What has it been, 100 years?
And it's signed. It's signed.
Yeah, Jeff, you just deserted it.
I did, didn't I?
How are you, Jeff?
Yes, you should be ashamed.
Well, hello. It's a spare, Carolyn. We have one and a spare. Okay,
Things are good here.
good.
Can't complain.
Yeah, Jeff, you just deserted it. Somebody's talking, but I can't hear them.
I didn't mean to desert you though.
Oh, yeah, just run off.
You
I
Well, at
deserted.
least you came back.
sometimes I
Well,
talk to Scooter though, because
yeah.
we're both fans of Ed Bassmaster.
Oh,
He's hilarious. I don't know if you guys watch him.
I don't think I've ever seen him.
It's kind of a candid camera kind of stuff, but he dresses up as these characters, and
Oh,
they've got a hidden camera, and it's just amazing how believable he is, as these different characters are so different. And what he'll do is he'll target like this one person, and he'll show up to them in these different outfits, and they just don't realize they're talking to the same person.
oh, really?
He did it to a crew that was working on his house. So all he would have to do is, like slip back into the house, change outfit, and come in. And there was only like one guy on the crew of people working on his house that was like I think that's the same guy. But he was like up to 4 different characters, and he had all the rest of them fooled.
Oh, no kidding.
It's hilarious.
Huh.
Oh man, that's a nice piece of marble.
Yeah, it's pretty, isn't it?
Or is that a countertop?
Yeah,
Wow, I like it.
that's Carolyn's countertop in her fake kitchen.
Oh, yeah.
Her
Yeah,
pretend
that's really
kitchen.
nice. I've always been a fan of marble.
I think it's granite,
Ah.
actually. I wouldn't swear to it.
I was
Where-
sitting here speaking and I didn't realize I was on mute, which was
Oh, boy.
very
Uh-oh.
good. Okay.
Well, I wondered what happened to you.
Yeah. Okay. So I've got my paper. I've got some of these watercolors, and they had a sale on Amazon for the what are they called? The Milani, Milani. I'm not even familiar with them, but they're supposed to be really, really good watercolors. And they were really on sale today. Crazily. But those are my old watercolors that I used to color the coffee filters. Oh boy. I'm looking for, who's that? Did you hear an echo?
I heard something.
For
Oh,
a second,
yeah, it's not there now.
it's gone.
Sharon,
Might have been me.
X-rays, Jeff. So if you hear the machine, just hold your breath and stay still.
I'm
Do
not
what?
doing anything.
She
I'm not
has
doing
something
anything.
that sounds like she's taking X-rays. It's just
I
like
am.
when they take an X-ray at the doctor's office and you hear that little sound.
Oh yeah, yeah.
So we tease Sharon because it comes from her mic or something. Go, oh gosh, did you get that one? Was that a good
Good X-ray. Do we have to repeat it?
X-ray, or do we have to repeat it? She just had a good picture. What's going on there?
Should I put like a lead vest over my lower region?
Wouldn't be a
Oh.
bad idea.
Now, Margot wanted me to look in these slippers while I'm here. She said there was stuff packed in them. And she's
Oh.
right. There is stuff in the slippers. I thought it was
Uh-oh.
stuffing. I thought she was stuffing my big giant slippers. The big giant slippers. But she said that they were gifts from people. So let's see what they are. This says, send to Carolyn from Sharon.
Oh, really?
Yeah.
What'd I get you?
Oh, it's very pretty. Very pretty ring.
Oh, you got her a ring.
Good. Yeah.
You are so sweet.
How does it look on you?
Let me see.
Oh, very pretty.
Isn't it? Very nice. Thank you, Sharon.
Very pretty.
And let's see, there's another
Wait,
Prezi.
when you spotlight it, I want to see it.
Okay, I will. Let's just look at this. Okay. This is from Ruff. Oh, isn't that funny? And Ruff's on panel too. This
Oh,
is your
yeah.
life. This is your life.
Yeah.
This is Carolyn. This seahorse is from Ruff. And Margot's not here, right?
Well, she will be.
was.
She'll be here.
All right.
Oh,
Trying to get this out of the thing here. Wooden seahorse. Oh, it's very cute. It's a wooden seahorse.
There you go.
Very
look at
cute. Thank you, Ruff.
You're welcome.
Thank you. Very cute. Okay, now, what was I going to do? Now I've got to find my stuff to find my watercolors here. Okay. Watercolors, watercolors. I'm halfway. We've got all the new shelves that I bought down, assembled, and they're down in the basement. And tomorrow I'm going to seriously try to rotate stuff out and in. I would just put those. You guys can talk. It's not. Nobody would bite your head off.
I would hope not.
What have you been up to? Are you all ready for Christmas, Jeff?
Not at all. Not at all. I'm gonna probably lean on Amazon very heavily.
Oh, yes, absolutely.
My son asked me today, Mom, what do you want for Christmas? I said, are you out right now? He said he's out. Yeah, he's out with his fiance right then. He said, but no, you don't have to give it to me right now, but you got to start getting a move on what you want. And the other day I knew of something. I said, oh, I could ask for that. Now I can't for the life of me remember. And this happens.
Remember what it was.
Yeah.
I did the exact same thing. There's something I really wanted, and I can't remember what it is.
Yeah, and it was perfect. I'm like, oh, that's perfect. It was a perfect price point. Everything was perfect about it. Now I can't remember.
Yeah, me either.
And what? I don't know. Crazy. I
Yeah,
can't.
the memory is a funny thing. I like when I go to the supermarket, if I need 3 things and I keep saying them to myself, I might even sing them. And I'll take the first letter of each and I'll make a word. It's like, okay, I need to get these 3 letters.
I've done that. And mnemonic.
And then I'll get in there and I can't remember what the letter meant. You know, what is it?
Yeah. What is that? Yeah.
Who's that?
Hi, Margot.
Hi.
Oh, hi. I opened the presents.
Coming.
Oh, good.
Yeah. I'm trying to find where I put my. I'm just going to use these watercolors. It'll work even with these. Okay.
So you're actually going to paint something from like a blank canvas, right? When you said watercolors, I thought it was like a picture.
Yeah. There's like
that
this.
you-
There's a lot of these flowers. Like they're just fun to do. It's relaxing, you know. And my daughter's really she's doing a lot of different illustrations. Well, she's written a book that is almost ready to be published, and then she's also going for a master's in fictional writing, her second master's, and while she's working full time. But she is doing illustrating now and painting, and every day she does these Facebook stories like of these paintings.
I feel so lazy hearing about her.
I know, right?
I'm not an achiever like that. Wow.
Yeah. She's pretty determined there. Now let me see. I was watching something today, where's my thing? She's gonna tell me how to do this. So, you have your tree up or anything?
I'm ashamed to say no. We might this week, or might do something. We
Yeah.
we don't do
We're
a
kind of
whole
in the
lot.
same
We
position.
end up going and visiting, and
Oh,
so
yeah.
not much happens here.
We do the same.
So why make a mess here that you just got to clean up later? Nobody's gonna see it.
I'm with you, Jeff.
I like to just stare at the tree, though. I can't help myself.
I
just
do
like
too.
I would
But
love
I
it if
think I would.
somebody come put it up for me.
But it's going too fast already. Like it's like,
Oh,
Yes.
way too
every
fast. I
time
know.
it's getting faster and faster. When you're a kid, when somebody says, "Oh my gosh, it's Thanksgiving," oh, in 4 weeks it'll be Christmas, you're like, "Oh, that's so long." Now
know.
it's literally like Thanksgiving, and 2 days later is Christmas.
Way too fast.
Yeah,
I need more time.
Amen.
crazy
Ridiculous.
fast.
It's too fast, and it's like, and then it gets to the point like, gosh, if we could have a little more time, and you just think that you could, is everybody behind this year? How about we push it out a couple of weeks? All right, but nobody will agree to that because there's these people that have decorated their trees like in October, and they're the
Yeah.
ones that take them down on December 26th because they can't take it anymore.
Yeah.
Exactly. Let's see.
I'd like to be part of a family that can like move it all into mid-January, and then we just you can benefit from all the sales and
All the sales. I
Oh,
know.
yeah.
I've suggested it before, and my relatives
Nobody
would
ever
just
takes you up on it.
blink. Like, I know.
There are people like that, I guess, that don't get together and get together after, but
Yeah.
I know I'd probably get into a tree if we could do a real tree, but my wife's kind of allergic to, the real tree. But
Yeah, I am too. But
I mean, I love to look
really
at a
like
tree
them.
too, but I love the smell as well.
Yeah. It's so nice.
I really wanted to do mine.
They have pine incense you can burn.
Pine incense?
Yeah, it smells like pine.
Oh, no kidding.
Have one of those what do you call
That'd
it?
be
Those, like a
nice.
scentsy candle.
Yeah.
And you put little pieces of wax in it. I wonder if I could find some like Christmas tree smelling.
Oh, like a wax warmer.
Oh, I'm sure you can. Wax warmers, yeah,
Oh, yeah. They have it.
definitely. Definitively. So you didn't follow this Maya 261 million case at all?
No, I've been so focused on the Idaho case, and like almost daily I go on lives, if they're happening.
I don't know. I can't like get it. Like there's so much time before that goes to trial. Like, see, I would get like seriously bored. Like, what's new? Like, you know what I mean? Like, what's new? Like,
Well, what's troubling? I agree with you. It's so far away, but I think I see so many YouTube creators that are they're coming up with such wild theories.
oh, that you know why, right?
Why is that?
Why? Because it was
likes.
hugely popular. They made good money. It's just like the Chris Watts case, and they had to keep it going. So let's take it another season. Now they've got this case that was hugely popular, and it's really kind of stagnant now. So what can they do? They can, well, go on and make up stuff, and that's what they do. And sadly, they do well at it because there's people that are so invested in it that they don't really care if it's true or not, whatever you're telling them.
Right.
Yeah.
It's funny though, what I find that there are channels that feel so strongly that Brian Koberger's innocent, and it's like it's a sin to
Really?
insinuate.
Are
his
you
guilt.
serious?
Yeah. And what's funny though is like, they'll jump on you. They say, Brian Koberg's presumed innocent, but we're going to go ahead and talk about how we think the law enforcement is guilty and the survivors are guilty. And it's like, aren't they presumed innocent too, or don't they deserve the same respect? They
Murdered
go
in their
overboard though. I think it's over respect actually, but
Oh my goodness. They really think that he's innocent. They all, I mean, like I think all the
Yeah.
murderers have a fan club of some sort. Yeah.
Oh, the theories
Yeah,
are just
too.
crazy. They from underground tunnels under the house to drug cartels to
Oh my
yeah,
goodness.
it's
Yeah,
really
see, that's just like it's like fantasy. You know what it's like? They probably make good writers. Like, so they're writing another storyline. They think they're writing a movie, maybe a
right.
screenplay. That's what it is, right?
Yeah, yeah.
That's what I
Yeah,
think it
it's how
is.
creative can you get? How creative can you be?
Yeah.
But I mean, I think people getting hurt, you know, these two survivors, they don't deserve to be you know, I don't see anything that they didn't call 911 for 8 hours. I mean, I give them a benefit of a doubt. 8 hours is a good night's sleep, right? I mean,
Yeah.
I just think they couldn't have known. And I have a theory where I think it makes total sense that they wouldn't have known that it was that they that anybody, was unalived in that house.
Well, the one saw him walk past her though, but that's what I think people have the most problems with, right? Because she went in there and was she in shock that she went in there? She didn't know, what was going on.
Yeah, I think
But
I think it was I just get the sense that yeah, she saw him walk by, but I think she thought, okay, the source of all this noise that's waking me up again and again when I'm just trying to sleep and I'm yelling at my roommates, I'm trying to like shut up. And I see the guy walk out and it's like, okay, he was weird, but at least now I can get back to sleep. But I think he looked weird, odd, but I don't think she thought, oh my gosh, I think he just probably unalived my roommates, but I'm going to sleep. That
Yeah.
I just don't see
Right.
a person doing
No,
that.
no, no, no,
And
no.
the thing is, my theory is that the killer, I purchased the same knife just because I was curious. I was that curious and I planned to do a video with it. But I didn't realize that the butt end, of that knife is just like a hammer. I mean, you could hammer nails, and I think in the Marines they actually, they do that. They put their tents up. They use it as a tool. Um,
Mm.
but actually, too, this was interesting. Tonight on the live stream, this other guy mentioned Ted Bundy, and that Ted
yeah.
Bundy used like a piece of wood to knock out his
Oh
victim.
yeah. Right.
So, if Brian Koberger studied serial killers, um, I mean, I think you take the butt end of this knife that's in essence a hammer. If you can knock your victim out and then do the awful stuff with the other
Mhm.
end of the weapon, that's a quiet crime. And people even in the house wouldn't hear that. So it's very likely that was maybe his plan, and that's probably what he carried out. Um, but I mean, there's a couple things in the PCA that talks about, Dylan thought she heard the dog upstairs, somebody playing with the dog.
Right.
See, I think that he first went into Maddie's room. I think she appeared very drunk on the grub truck camera. I think
Hmm.
she was probably passed out and laying in bed. And I think he went in there. All he would have had to do is just, hit her in the head and then do what he was doing. But I think it was Kaylee was across the hall. And I think the dog probably was aware somebody's in here and there's the smell of blood, maybe.
Right.
And the dog woke up Kaylee and probably woke up Dylan downstairs too. And then Kaylee went in and then saw what was happening. And then I think she probably got a blow to the head. And I understand I think her face was very damaged. And I wonder if I always thought it was the sharp end of the knife, but maybe I'm thinking it could have been, the other end.
Hmm.
And so, because what does a PCA say? She said, there's somebody here. So
Right.
is that something you say if you're in the same room with Maddie? I think that's something you say if you're in and you're in your room and the dog has alerted you. And when my dog starts barking, I was like, oh, somebody's ordered, Uber Eats or DoorDash.
Mm-hmm.
And
Right.
I would say the same thing. Oh, somebody's here. The dog is acting a certain way.
Right. Somebody's here. Yeah. Hmm.
But then downstairs, when he goes downstairs, there's Xana posted a comment to TikTok. What's interesting is that everybody thought it was just the word queen, and I talked to somebody who informed me that her last post was actually at 4:12, and it was said, "Never forget the foundation in the bathtub." And
What?
apparently this post was posted to an old friend's TikTok. So this was a friend, I think, that goes back to like grade school. And I think the story might be that her and this friend maybe spilled the mother's makeup, the foundation, in the bathtub.
Oh.
And so I think that's what she was referring to, which I think if that's true, that makes it a very credible post, because some might say, well, what if she was unalived and then somebody used her TikTok? But it's like, if you're saying something on an old friend's post that makes sense to that friend, I think you can verify that probably is definitely her. But here's my thought. I think, she ordered DoorDash food, and if she's anything like my wife, food comes, I'm not likely to, but she will say, go wash your hands. So I think Ethan went to the bathroom, to wash his hands, but probably, I don't know, they were at a party, they were drinking, maybe that's the other thing too. I don't know how drunk they were. We know how drunk Kaylee and Maddie were because we saw them on camera. But if Ethan, let's imagine Ethan and Xana are a little drunk. So he's sent to the bathroom and he's in the bathroom doing his thing. The killer comes in, she's on TikTok, maybe has her back to the door, and he just comes in and bops her in the head. Now she's laying on the floor. And maybe she's crying, which is the other thing Dylan heard. She heard some crying coming from across the hall. Maybe the killer hears Ethan about to come out of the bathroom, maybe a toilet flush. I don't know. But I picture Ethan coming out of the bathroom and seeing her on the floor. Now, maybe he thinks she fell because they're both drunk. And I think he comes in and he says what it says in the PCA that Dylan heard. It's okay. I'm going to help you. A lot of people thought that was the killer that said those words, but I think it was Ethan. And I think the killer was, just kind of tucked himself in the corner of the room. So Ethan didn't know he was in there. So Ethan bends down to help Xana and then is ambushed. And then they're both, Xana's kind of knocked out because she was hit in the head. Ethan doesn't expect a thing that's about to hit him. And then boom, you have 4 victims with one knife, very quiet. And and it I don't know, I can make sense of the things that the Dylan did here. So
Yeah, it's okay. I'm going to help you. And that was heard by Dylan, right?
yeah, because it was either a very cold, callous thing to say to a victim if the killer said it. But it makes more sense that it was Ethan that said it. And the other thing too, if Dylan was across the hall and the 2 things that she heard from Xana's room was some crying, but then a reassuring voice that's saying, it's okay, I'm going to help you. If she did think that's Ethan, so something must be going on with Xana and Ethan, but it sounds like it's under control. And then this weird guy walks by and who knows, Dylan maybe might have thought like, was this the DoorDash guy? Maybe he came in, brought the food in, but I really think that Dylan did not like go to bed thinking like her roommates were unalived and she doesn't care and she's just going to go to sleep. But that's what a lot of people imply. And I think that's just,
No.
Occam's razor says that's not what occurred.
Right. How could you just like
But
sleep?
Xana had defensive wounds. The rumor or story was that she fought back.
Right. Although, I heard somebody describe defensive wounds. It can be 2 things. It's fighting back, yes, or it can just be, putting your hands up in front of you to block what's coming at you. So, maybe not
Well, I think
necessarily
they said she grabbed the knife. She almost severed some fingers.
severed fingers. Yeah, I heard that.
Yeah. So and she said that she heard somebody, or she said somebody's in the house or somebody's here. She said something about that. I think she went into the kitchen to put her throw her bag away. And I think she either heard him upstairs or saw him
Yeah, I think
and ran
Dylan said
back
she
to her
thought it
room.
was thought it was Kaylee's voice she heard saying there's somebody here.
Oh, I thought she said Xana.
Yeah, it said in the PCA that she thought it was Kaylee. That's actually good, and it's kind of important because she mentions Kaylee that she thought it was Kaylee, but with regards to the crying and the "it's okay, I'm going to help you," she doesn't say, or at least it doesn't say in the PCA, who she thought those voices were. She
Oh,
thought it was
okay.
a male voice. It said, and it says a male voice. It's something to the effect of "it's okay, I'm going to help you." So probably wasn't those exact words, but again, if that's the sentiment that she felt she heard, it's like, it'd be easy to assume it's like, okay, it's just, this was the last person that walked by, the last person in a party house, it's crazy around here. There's all kinds of people coming through this house. Okay, this guy's finally gone. Now I can go to sleep. Now if she'd have seen like he's got a big old knife in his hand, I mean, I'm sure that would have been different.
Well, yeah. He had to have been holding it.
Yeah, I think he probably, like I said, I bought one. You could just hold it right up against your leg and walk out. Nobody would know
Yeah.
you got it.
But he didn't think anybody was there, so he wasn't going to be hiding anything. And you
Yeah, I
think,
think he was blinded by that good vibes neon light that they have on the wall, because it would have been shining right in his face, would have been lighting his face up perfectly for her to see his eyebrows.
he had on he didn't have on a hoodie over his face, did he?
He had a mask, but that's why I think the only real description other than his build was the eyebrows, the bushy eyebrows that he had. Here's my theory about the bushy eyebrows, though. When he was coming down from the top floor, there's that little step up into the living room. And if you're unaware of that in the dark, he probably tripped on that as he was going to Xana's room. So when he's on his way back, now he's ready to exit the house and go out the way he came. I have a feeling he's looking down at that step to make sure he doesn't trip a second time. And, when you're looking down and you got light shining right in your face, it's your eyebrows are going to be very, I think, distinct. It's like they're lit to see.
Do you think he targeted one of them or two of them, or no?
I really think it wouldn't surprise me if he had like multiple houses that he thought, oh, this one could work, or this house could work. And this particular night, I just wonder if, okay, yeah, everything is perfect. It's a time of night. Yeah. I've cased this place. I've seen what time they go to bed. Part of me wonders too, if he didn't intend to only go into Maddie's room, do whatever he planned to do only with her and leave. But it was a dog across the hall that woke up Kaylee across the hall. And then that could have, who knows, changed the whole plan. Unless, some people have the theory that he wanted, a big story. He studied under Catherine Ramsland, who wrote the autobiography for BTK, serial killer. And I've heard some theories where it's like he wanted a good number of people unalive so that this would be a big story. I wonder though, if he'd have gotten away with it, is it possible that he would be twisted in the way that he hoped to be maybe a professor someday in a classroom?
Oh,
like, okay, we're going to talk about the unsolved Idaho mystery,
Mm-hmm.
I know, but did he really think that he would get away with that? I mean, that's what I'm saying.
He was like Chris Watts. He didn't have an end plan. I mean, he didn't think it all the way through. What's going to happen after? He just was concentrating on killing. I think he was after the two girls, Maddie and Kaylee.
Well, his phone his phone pinged, I think, 12 times in that area prior to the murders, and of those 12 times, only one was like, I think, during the day. All the others were like around the time, wee hours of the night.
Mm-hmm.
So I wonder if he was like, because those roads are dark, and he had he had his phone turned off during the time of the murder, so he wouldn't have the benefit of GPS, I don't think, unless he's got a old TomTom or something.
Yeah.
But I wonder if it was like, okay, I've practiced this route over and over again in the dark.
That's pretty,
Let me go back
Carolyn.
one time during the day just to be sure I see where the roads are, potholes, or last thing I want to do is be going off the side of the road and getting stuck. And
Maybe. Interesting theory.
but yeah, my mind has been kind of been saturated with just thinking about this case more than other stuff. And I've got
Yeah,
on
I
my
can't
YouTube
wait
channel.
for the trial.
It's what?
I can't wait for the trial.
Oh, me too. Yeah.
So
Yeah, but
how's it go-
I don't see how he could get away. See, now, I know Casey Anthony, we were dealt a real blow, those of us that saw that trial. But today, it's like, I see like everybody that gets up there, they pretty much have good evidence. Just like, like this Donna Adelson, you get follow that at all. How in the world, like, if I was her, just be like, okay, well, that's it, and I know she's not going to do that, but she's going to go through this trial and she's going to be convicted just the same. There's so much evidence on this woman.
Yeah.
And, I just don't see how Brian Koberger, he's going to get off of this, and it's just going to be years of, them prepping for this trial and same outcome. All this stuff is like a pipe dream to think that any defense that he has. I mean, the evidence is there.
Yeah.
Yep.
So I don't know.
Yeah, and there's so many cameras that the law enforcement has to their benefit, where the public can't see those. But what little I can see, I feel like, gosh, I think they've got the right guy for sure.
Oh yeah.
But it does amaze me, the
I
people
think
that are
so.
like, they have nothing on him. They have nothing. He's innocent.
But
He can
they
stay
think
in
they
my
say
just
house,
need
that
something
there's
to argue
people
about.
automatically on YouTube that just do that. Like they will constantly go after somebody kills someone, they're immediately taking the side of the killer.
Yeah.
Yeah, that's just the way it goes.
They're like
So-
contrarians. They go against the flow.
They have to. It's I don't know.
Let's get a
And I
treat.
see a lot, there's so much disdain for law enforcement that I think that really is what fuels it fuels the way they think and the conclusions they come to, because of surely law enforcement is corrupt and,
Mhm. Right.
But I like to say, like in the beginning of this case, I like to say when we all thought it was one of the JHACs, the boyfriend and the other JHAC,
Right.
I think law enforcement said, "Hold my beer." And then they went to work and they,
Right. Because they're always, have stuff behind the scenes, and it's hard sometimes, like even for, on a way to will tell us what's going on, but they can't.
Yeah.
They're compromised the case. But yeah, everybody's used to like such immediate gratification and wanting to know everything, and you don't. And they've already, by the time they release the names, when people go on social media looking, they have experts in there that have already looked at every piece of social media. So you're not going to find, it'd be like really rare if you found something that law enforcement didn't already know about,
right.
Mhm.
because they have teams of people that do that.
That's a good question for the next time I'm on a live, because I know these people go on like 4-hour lives and they go to every day. And it's like, I'm going to ask that. Has any of you been contacted by law enforcement because if you're so brilliant that you came up with something that they didn't already know?
Yeah, no, law enforcement is probably laughing at them. I'm telling you.
Yeah.
It's I don't know, some crazy theories.
But it's
Yeah.
interesting. The main thing that sticks in my mind is that on that Linda Lane camera at 4:07 and 30 seconds, you see the white car pass by the camera for the 5th time. And that 5th time, he's driving notably faster than all the other times. And he's headed in the direction, headed straight for the back of that house. That's 4:07. And then at 4:21, I hear what sounds like a trunk slam shut. And I just so happen to have a friend who's got a 2016 Elantra. And I took a little video. I stood way back and I took a video of him slamming his trunk just so I could compare the trunk slam sounds. Now, I have a feeling sedans that size, probably all their trunks sound the same. So it's not really that scientific. But when I hit play and listened to both of them, and I thought, oh my gosh, they sound the same to me.
Mm-hmm.
But so the trunk slams at 4:21, and 18 seconds later, you hear the engine and the car taking off like a bat out of heck. And, you know, at first I thought the sound of the trunk, I thought it was a car door, but I thought, why would he close the door of the car and wait 18 seconds to take off like that? And then it hit me. It's like, okay, it makes more sense. That does sound like a trunk. And you close the trunk. Now you got to get into the car. And if you've got any kind of red stuff left on you, that, because I think he put all the red stuff in, like maybe he had a big plastic bin or something that he put everything in.
Right.
There's a guy who's got a theory. He wrote a 17-page theory, and they shared it on this guy's YouTube channel. But he used to be a surfer, and what they would do when they'd finish surfing, so that they didn't get sand brought into the car, they would stand in a big plastic bin and just take all their stuff off and get, all the sand falls into the bin.
Right.
And, so his theory was that it was either a tarp or a plastic bin that. See, I think a tarp could, before he goes into the house, he could just throw a tarp down at the back of the house. It's like, this is where I'm going to undress of all this stuff. Kind of like when you come in from the, sledding and you don't want to get snow on the floor. But anyway, I think all that ends up in the trunk, so that now he's getting into the car almost naked, but maybe he's got a few drops on his face or something. So all he's got to do is get in the car and just be sure he doesn't touch his face. But I remember I filmed a surgeon once. It was kind of wild. I'd never been in a surgery room. This guy was having his carotid artery like scraped, so they cut in with a laser, but it was cool. They were listening to like rock music in the operating room, and
Oh yes, they do.
the surgeons got like tennis shoes on and jeans, but I noticed when I was filming them, and when at the end of surgery, they take their gloves off and they're very careful to. Now, granted, they're going to wash their hands too, but the idea of that like carried over into this case, and I thought, is that what he did? He just meticulously took everything off so that it all went into the tarp or the bucket or the bin, and he's getting in the car. And everybody was like marveling, like, well, how come there was no DNA in the passenger compartment in the car at all? It's like, well, yeah, plastic and knowing what you're doing. That's the other thing. If he was just some crazy dude, it'd be one thing, but he's like somebody who's studied this kind of thing. So,
Right. Yeah, I know. Did he really just think like he was going to get away with this?
well, he was fired from his yet another job. I think he's got a long list of jobs that he's been fired from.
Yeah, he don't play well with others.
Yeah, he didn't play nice.
No, he did not play well.
But I think he got the official letter that he was fired on the 19th of December, and then he was arrested like after that, and it's funny on these live streams how people will just lie just so that because their theory can only work if they believe the lie.
Oh my goodness, Jeff, we had people in the Watts case that had fake insiders that said they worked in Anadarko, and they knew like the things that didn't even exist, like that it's they didn't even understand that Survey 319 was a ranch, and they were like, oh yeah, there's big observation towers, and I was one of the people that worked in them. And do you know, Jeff, I was sitting there, right? Then I was like pretty new to this, and I thought, oh wow, these people in the chat are going to go ballistic and say, no, Survey 319 doesn't have that. And what did I see? Oh, wow. Like, I couldn't believe it. Half the time when the strangest theory or something would come out, I would say immediately, they're going to get shot down. Mm-mm. It's the craziest thing I've ever seen.
Yeah, it's the same.
People
same
just go, yeah, just go
Yeah,
and
lose
say,
my
and,
mind.
even though it's like so easy to prove, and then like the people that do realize it, they're scared to even speak out because later on, if you mention it, they'll say, oh yeah, my gosh, I knew that. I was thinking like, what's going on there? How could these people believe this? But they do. And they're like, oh, this one had an insider. He saw, Chris, and she was there that day. I'm like, do you guys see that? That's not even possible. That it
Yeah.
wasn't like that. You're talking about a battlefield that, it's like, I don't know. It's so crazy, but yeah, anything to keep it going. Just like I said, there was this politician and up above me, and he was promising people there was going to be an arrest in 2
Oh,
weeks. And he
Lord.
was collecting money for this billboard. And I just like shaking my head. Like, are you really?
Mm.
You gotta be kidding. But people believed it. People donated to this billboard, and then he had to go on and, I'd say, oh, well, he said he had inside information. His friend who was in politics worked in this, the DA's office down there, and they were reopening the case. That's how far they'll go.
Mm.
It's really bad. And I guess with every case, the whole thing starts all over again because people want more installments. They're ready for another season.
Right, right.
And people will give it to them. Some people
Yeah,
have
like
no
turns it
ethics.
into like a soap opera. Like
Exactly. And there's no ethics. So like it's either might start out as like, oh, well, we're just speculating. And then it turns to, well, we need something more. Oh, that's how they got that crazy. How many people thought that somebody's mother called in and said that, all that stuff about being there that morning of, right? And all this crap, and it was all fake. It's like, I don't know. And it's ridiculous. And people have to remember, like, these are real families. And you're like, you go on there and you say, like, you have this information and it's fake, they should be liable for all that crap that they know, and they're taking in these calls. And a lot of them know it's fake and they do it and they think like, oh, well, I'm not hurting anybody.
That's
that's
very
terrible.
pretty, Carolyn.
Oh, thanks. I'm just fooling around, just
It's
trying to
pretty.
Yeah, that looks great, Carolyn. I wish I could do that.
Well, you
Yeah.
can.
Maybe I should try.
Just, yeah.
No, I can't.
Yeah, you can. My daughter just had me start this.
Oh, don't tell me you just started doing this.
Yes, I did when she was home.
Wow.
Carolyn.
I'm serious, Ruff. Oh, God.
Shut the door.
No, it's
Another
pretty
life
easy. It's
you
very
are,
relaxing.
artist.
It's just
It's very pretty. I'm very impressed.
very relaxing.
That is pretty.
Mm-hmm.
Need to put a little bee somewhere.
You all saw about that house that exploded in
Oh, yeah.
Virginia?
Right.
How many people died? Was it just him?
Just the one guy, I think.
I thought that was the duplex he was in.
Yeah, but I think it was an hour and a half before the explosion, they evacuated the people on the other side of the house.
No police officers got hurt.
There were three, I think, that had minor injuries, but nobody had to go to the hospital or anything. That was very fortunate. They could have lost people.
That was
that
horrible.
where that house was 2 blocks from where I used to live. I was like,
Wow.
just around the corner. I could have from the house I lived at, if I'd have stepped out in the back of the kitchen, I could have seen that house.
Oh, wow.
Yeah, I was surprised when I heard Arlington, Virginia. I thought, what? And then all these these crime YouTubers that I go on their shows and I talk to all the time, and they're talking about Arlington. I couldn't believe it. It's like, whoa, this is wild.
Now, what was that again? Wait, so that guy just he brought a bunch of flares in the house and then
Yeah,
There
so
was
he,
something, I was just thinking that too. What else was there to blow that place up like that? Because that was a big explosion.
yeah, they still haven't officially said what the actual cause of that was. So it's
Yeah.
still,
It can't be just flares.
yeah. And the thing
Well,
too is, I don't think he could fill the place with like gas if he turned the gas on while he's firing flares. I mean, it would have ignited
well, I
early,
heard that
started a
he
fire.
was firing flares into the neighborhood, and they came with a search warrant because it had been reported that he'd fired 40 or
Yeah, it was like 30 to
48
40 flares.
flares into the neighborhood. And then, not sure if I heard that they heard gunfire inside the house and then the explosion.
Yeah, I think the neighbor said that he saw the SWAT truck trying to maybe breach the front door or something or the window, and he started firing a gun at the police, so they backed off and then kind of repositioned themselves, and then they started to move towards the house again, and the house blew up.
Yeah.
But
That's,
we were looking at his LinkedIn account, and he had some really bizarre stuff posted on there. His one of his divorce documents. Apparently it was a really ugly divorce. And but I mean, like Bill Clinton is mentioned in the document, and all kinds of, I think even Spock from Star Trek, and I think the judge, I think, said something like, this is like all just a bunch of fantasy, and they just kind of threw it out. But here's the weird thing. I thought he posted on there that he noticed CNN posted a video on their YouTube channel, and the video just happened to be 8 minutes and 44 seconds, which is his address number. He lived at 844, and he was convinced that CNN was conspiring. And he's an Asian man, and he really thought that his neighbors, I guess, on the duplex on the other side, were going to kill him on December 7th, like the anniversary of Pearl Harbor, because I guess he's Asian.
Oh, it sounds like paranoid schizophrenia, doesn't it?
Yeah, yeah, yeah. I think he was very troubled man. And apparently all his windows were covered with either aluminum foil or garbage bags. And
Oh boy.
What did he do? What were they looking for him for? I can't remember this. I just remember the house exploding.
what were they? What?
What were they going there for? What did he do?
Well, yeah, that's what started it, apparently, because I know right where that house is. Luckily, there's a fire station that you can see the house from the fire station.
Yeah.
Apparently there was a police officer at that fire station, from what I heard, and he's noticed the flares being fired over into the soccer field with kids and people are there,
Uh-huh.
and very dangerous situation. And I guess they went there, and I guess they had to wait a little bit to get a search warrant, and that's what. But I don't know. I don't know if could a big old box of flares that all got ignited at once,
That,
could it do that?
that was a big explosion. That was like like a bomb or something. It was like it took the whole thing down. Like,
Yeah, both sides of that house gone.
yeah.
That was amazing.
I'll buy that, Carolyn.
Yeah.
No. I've been talking to her about this now, Sharon. No,
Huh?
no. I've been talking
No.
to her about this painting. No.
I know, but I had to eat dinner. I had to eat dinner. Oh, it's only 3 a.m., but I finally ate.
Okay, so what's that got to do with me buying her picture?
I didn't hear you say you wanted to buy it.
So easy. I love you, Sharon.
Hmm?
I do want it though, but yeah, we can talk about it.
You gonna have a bidding war?
Well, maybe we can share it. I can have it for a while and then I'll send it back to Sharon.
Joint custody?
Joint custody. Yeah.
That works for me.
She can paint another one, so we can,
And
well,
paint another one, yeah.
Do
I-
another one.
constantly
No,
have.
I'd like to try to do one on, I would like to see what it would be like on, like one of those wood plaques if I did it on one, like direct-
Watercolor.
Yeah,
Mhm.
like on one of these, like I just fool around and, you know, see on something like this, you know,
Oh, yes.
see what that would look like. What's the worst
I
that's gonna
like it
happen?
like that on that paper, actually.
You just have to paint it
I would
over.
frame it and mat it.
Mm-hmm.
That.
But I'd like to see what one would look like on wood too, you know?
Mm.
I would
But
like to see.
Yeah, on wood would be cool, but I would frame and mat that. I have one similar to it that I bought. Oh my gosh, 40
Oh,
years
really?
ago. I put them side by side. They're similar enough.
Similar to this?
Mhm.
Okay, babe, you can have it. I won't fight for it.
So mine has a blue color.
I'm sure I can paint another one.
I'll give
Very
it-
relaxing. I want to do some watercolor every morning because I think it's very relaxing. It really is. I plan to come down and do it
Are you
today.
looking at something or are you just making it up as you go?
Well, I look at a lady that just showed it the basic flower, and then I just kind of look what she's doing, and then I did my
I
own
see.
thing.
I
Yes,
see.
it's my daughter. Well, I'm trying to find the ones we did like my first. I don't know where. But
Oh, she can have a show.
very relaxing.
I like how, I mean, they really look like blooming flowers. If I did that, it would just look like a big old blob.
No, I'm telling you, it's easier than you would think.
I
Tomorrow,
can't.
I'm gonna try this
what
little
to see,
medium
though.
basket that she has.
Well, you're making it look easy, but I don't think it's as easy as
I just did it right in front of you.
I
But
know
it's
you
not-
did. The thing is that some people have more of a knack for it than others. I'm not so
Yes.
sure I would be. Do another one.
Another
Yeah,
one?
I couldn't. Yeah, she needs two. She needs a pair.
Oh.
Are
I
you
just
sure you
like
don't
this.
have a super artist there with you, and that's the hands we were watching?
Yeah.
Well,
I know, right?
That was her
We
daughter.
don't know
doing
for sure that's Carolyn's hands, do we?
no, not for sure. But I have the ring on, right?
Oh,
Oh,
that's
yeah.
true. That's true.
She's still wearing her ring.
I have the ring. Well, Sharon just gave it to me and said, put it on.
Well, what did you do with my seahorse?
The seahorse is right here. I can't wear it on my hand, Rob. Otherwise, that'd be really painful.
Did you throw it away?
No, it's right here. Stop. Right here.
At any point, was Carolyn typing a message into the chat while we were
I
watching?
thought maybe
this
you might have
happening?
flushed it down.
No, not at all. Not at
So
all.
what kind of paintbrushes? Do you use decent paintbrushes or do you just use
No,
cheap?
these are just cheap punch brushes. I don't have any. These are just
Like
like
that right there that you have, that's watercolor?
this is what, and this is this like cheap watercolor. You know, I bought this watercolor to color the water filters, but I did order some a set that these painters are using that was on really good sale on Amazon.
Yeah.
But
How much-
these, I mean, look, yeah, I can do it with those.
How much
What
was?
Hint, hint, hint.
The one on Amazon was on sale. It was like normally $36 on sale for $16 today.
Oh, just like the one you got.
No, it's better than this one. It's got like these highly pigmented like rectangular watercolors.
Uh-huh.
Oh,
It's this set that comes in this tin box, and all the people that are painting watercolor on YouTube, they all rave about the set. So I just went to look at it. I said, this is gonna be really expensive, I bet you. And it was on sale. It was like from 36 down to 16, some kind of
Wow.
lightning deal. And I'm like, okay, I'm gonna get myself that, treat myself.
oh, really?
Yeah.
You didn't tell us, did you?
I'll
No.
put the link in there. I'm sure. Let me go look now. I'm sure it's still
Yeah,
around.
but you said it was a lightning deal. It might not be there
But
anymore.
it's probably still there. They are. It hasn't been that long. I don't even think it's been 24 hours.
No, it's usually a timed deal, a lightning one.
Well, let me see. Maybe we'll get lucky. Let me see.
I just went to get my charger from my phone. I have all my treats laying beside my bed. I need to clean it out.
Yeah, I know, right?
I've got a.
I've got the colored
Thank you.
pencils and coloring books. Oh my gosh, I got so many color pencils. It's almost embarrassing.
And gel pens. You got some gel pens?
I do, as a matter of fact. Well, they're not gel pens. They're the Posca markers is what
I thought you
Yeah.
said jail pens.
I watched
What is
this
it?
lady,
What you use when you're in jail?
No.
Julie's,
Paint with
Julie's Passion for Color, I think it's called. Man, you should see how she does her work. Oh my gosh.
It's still on sale.
Where is it? Why can't I find it?
Put the link in the chat. It's $16.79. Regularly, what is it, $27? 27.
Oh man, I can't see in chat.
I'll put it in Slack too, and you can talk about it.
Okay, yeah, because I can't.
Let's do that.
And what kind of paper do you use? Oh, can you hear me? What kind of paper do you use?
That's just paper I got at Walmart. It's mixed media paper, a pad of it.
Really? And it's not warping or anything on you?
No, it's thick stuff. It's made from watercolor.
Hmm.
Yeah, it's not bleeding or nothing.
No, it's made for that.
Yeah, what's neat when I shrink the screen down and make it small, it looks real.
And people in the chat, as soon as I can get that there, I'll put a link if you want to check out the paints. They're super cool. Supposed to be really good ones. I don't know. See how it goes, but that YouTuber was going nuts. I watched a few of them and they all use this kind of paint. It's like, okay.
I don't know if any of you look at there's a YouTube channel called Game Show Flashback. They just posted
I've
three
seen
old
that.
episodes of The Price is Right from like from 2000.
Really?
Yeah, I love
Oh, really?
And the commercials, the old commercials are in them too. I love to watch that.
Oh, no kidding. I think the really hilarious ones are the Newlywed Game. Oh my god.
Yeah.
Bob
that's
Eubanks
it.
was a dog.
No,
Everything's an innuendo with him.
So they always talked about making whoopee.
Oh
Yeah.
yes.
And that was like really risque back then, but then Richard Dawson was really gross too.
Oh,
Yeah, he
I want
yeah.
to go over there and I'll talk to you. I'll leave it on that, but I just want to go over
Yeah,
there.
Richard Dawson's DNA was all over everybody. I'm gonna start using that phrase now. Make whoopee. See how many people get.
I just heard something about Richard Dawson that everybody had to be screened for herpes.
What?
Yeah, I just read that somewhere. I swear that everybody, like, because he kissed them so much, they all had to be screened for herpes. So that it's because he would kiss them. He wouldn't kiss them if they weren't clean.
He's still a dog.
Yeah.
You know, I saw something about a very small time game show where this guy was super creepy. I mean, he was like an older guy, and it was just made it obvious that he was all about the girls, and they're so cute, and even young girls, and it's like,
Hi, Catwoman. How are you?
creepy.
So skeevy type, huh?
Very
Yikes.
much. Very much. It's hard to watch.
Yeah, watercolor pencils. That could be interesting.
Okay, is Carolyn, the one you're talking about here is 36 colors?
$16. Yep, that's what I got.
36? Oh, I think I found them then.
I
then
just put it in Slack. Did you see it?
Yeah, there's some other ones at 32, 23, and one for 23. don't
The
look
link's in
bad.
Slack, Sharon.
$16.79?
Yeah, you go through the link in. Yeah, but you got to go through the link in Slack.
All right.
I like the other one, the 2-pack for 20.
$23.99. Yeah, that's a good deal too. That's
Look at that one, Sharon. That's
I found it. That's a quick one.
you guys are big spenders.
Same one. I found it.
That's a nice. I'm joking. I'm kidding around, rough. Because I did order some. I have some little metallic, so, but that's a very nice set, that $23 one. You know, I don't think that one was on sale when I looked today. I think they added that $23 one on there.
Oh, the 48 colors?
Yeah,
Mm-hmm.
That's what I'm looking at.
that's the one I want to get.
I kind of think so too, because.
See, and then the 52 color one comes with the water brush and that, but you can just buy that.
Yeah, there's too many dark ones in this one.
But there's
The other
a
one's got
20. What is the 28?
Well, I know it's watercolor, so they're going to obviously be much lighter, but still.
Yeah, these are that's the 36 is very vivid colors. Yeah, very dark. All right.
Oh yeah, 48.
Yeah, mine will be here.
12 metallic glitter solid.
See, we can have a watercolor night.
Yeah, we could.
Well, now I gotta find paper.
Oh, you can get that right at Walmart.
I ain't going to Walmart.
Oh,
And it is
okay.
12.
I thought you have that thing where they deliver all. You can just order a
I
pack.
do. I do. Walmart does deliver it, but so did Amazon.
Oh, okay.
Are they cheaper at Walmart?
No, I was just saying. Let me see. I'll show you one that's like kind of probably like what I have.
They've got brushes for $8.95. Too. That's a lot of brushes.
Yeah, you're gonna want the round. They mostly use like 8s. Look for an 8 round.
This has got a whole lot of different ones. 12 of them. Paint type watercolors.
And there's even like the I have some of them from the Dollar Tree, actually, the ones you put like the water in the brush itself. And
Oh, here's some for $4. Ooh, that's just $4.
make you holler.
Color, I mean, for the brushes. Comes with a lot of brushes.
Let me see.
Though I don't use it, Carolyn. Would these work?
Wait a minute.
What?
Let me see.
The one for 23 is it the same brand?
Yeah, it is, isn't it?
I've
Brand
already
Light
Mei-Liang.
Brand Lightwish.
No, it's Mei-Liang. They're all, aren't they Mei-Liang? They're all Mei-Liang.
That's my Ling or whatever, but the brand is
Mei-Liang.
Lightwish. That's the brand.
What do you mean it's Lightwish?
That's the name of the brand.
Okay, but this is the one that they have. Believe me, I looked on there.
Oh, yeah. Let's see. That one's 29. So it's
See those like cabbage roses? Those are really nice. I learned how to make those from some other lady.
this one's only 20% off.
Well, Carolyn, I just looked at the time. I better go.
Oh
to bed.
yeah, Jeff. Sorry, we got into the watercolors.
Oh,
Yeah,
this is
here,
great.
go
You know,
shop at the best.
Oh my goodness.
Just know if I gotta climb into bed very quietly.
Yes, quietly. How's your dog doing?
Oh, he's doing great. He's doing great.
Yeah.
Yeah, he's such a good. Oh my gosh, he's so like. The love of a dog like that is just like so amazing. You're just so happy to.
What
see
kind
him.
of dog is he again?
He's a German Shepherd Husky mix.
Yeah, big
Oh.
dog, right? Yeah.
Beautiful, and I got home. I had band practice tonight, and he was looking out the window as I left, and I felt like crying. It's just like, oh my gosh. And then when I got home, and he was so happy to see me, jumps up on me, but then he wanted to go out, so I was at the back door, and he walked to the back door, and he was like looking at me like, we're going out, and it's like, and I just looked at him, and I got real excited, and I said, come here, and his feet are skidding all over the place, and he like ran to me, and he almost knocked me over, and he did it like 3 times. I was like, my gosh, that is the love from him is just so unbelievable.
Yeah.
Wonderful dog. And I didn't want a dog. It was a family wanted the dog. They tricked me.
They tricked you.
Yeah, the picture they showed me was like it's this little dog. It's like, oh,
he's
let's go
cute.
see him. And then we go see him, and he's a horse. It's,
Yeah.
but I have no regrets. What's funny though, they wanted him, but now their interest is waned a little bit. But
Yeah.
that's okay because I
My
like it.
daughter-in-law is like praying that my female Scotty is pregnant, and I don't think my female Scotty is pregnant. And this girl, she has everything, like the little clothes, the little stroller, and I'm like, gee, I don't think she's pregnant. Okay, so it'll be, because I mean, literally, if she was, she'd have to be having puppies like any day. And watch tomorrow, those puppies. But I'm not seeing anything like that. But she's got her like heart set on this, and I'm like, I so don't want to disappoint her. But I think it's going to be not be.
I have to take a trip to PetSmart and
How'd
get
you-
something there.
No, she has. They have a dachshund, but they want a sibling for their dachshund.
Oh, I see.
That's my grand dog. Yeah, but I don't know.
There's a pet store not too far from here we went to, and I was looking at the prices. It was like $3,500 for these dogs. And it's like, whoa.
They went up since COVID. Yeah, COVID made all the breeders. I think the prices went way up, and then those what they used to call mutts are now designer dogs.
Oh, I know. That's so
Okay.
crazy.
Before it used to be like if you had a poodle and it mated with a Bichon or like a Cocker Spaniel, you'd be out of your mind, right? If you were breeding, oh my gosh, my whole. Now it's like, oh no, it's a cockapoo. Just call it a cockapoo. It's a designer dog. And but when I was growing up, that was like people were going insane. I remember my mother said there was some lady in the neighborhood, and she had this like champion, and then Cocker Spaniel went over, which a purebred Cocker Spaniel, and mated with the dog, and she flipped out, lost her mind. Now said she could never breed her dog again, never have the puppies. I'm like, how would they know, right? Tell me how someone knows your line is ruined. Like the people in the neighborhood, yeah, but how is that proven? And I just don't get it. I mean, I think some of this is like a little bit crazy what some of these people are saying. But anyway, so they have a mate with how do they know the next time that she gets it together with whatever breed it was? And somebody told me that a dog can get pregnant by two different fathers and have two completely different litters.
Yep.
Which is crazy, but yeah.
Well, they've got
Those people do DNA tests and make sure that.
Oh yeah, they
Yes.
do. Yeah.
There are dog DNA tests.
Yeah, but
Dog
I'm
tests.
saying like once after the dog is supposedly spoiled,
No.
how would you know the next time?
I know, right?
Like, I mean, really, I mean, that just seems a little extreme.
No, it's so weird. It's the dog's been ruined.
Oh yeah, I'll never have that line again. Like, well,
Fine.
don't worry, you don't have to report it. Big deal. You had a mistake. She don't kill her. I mean, my gosh, it's like ridiculous. I don't know.
And then
Dogs
did they
don't-
go on that the TV show with Maury Povich, and he said,
Yeah,
You are not the
you
father.
are
Not
the
the dog's
father,
father.
Fido.
Yeah,
Oh my gosh. But
you are not the father, Peanut.
okay, but it was fun. I mean, we probably met you around this time last year, right? Maybe a month before. Went the whole Idaho 4 business.
yeah.
Look at that.
Yeah, every time anyone brings up that wrecked
Oh, that car.
I always think about you guys in that live we did.
I know, right?
Do you ever see that woman?
No. I don't frequent that group anymore. Maybe she's still in there, and I don't know. But
I think she's still a Facebook friend, but I don't really use Facebook that much anymore.
that was a fun night. It's okay.
Yeah,
It's
yeah,
fun.
that was really something.
Yeah.
I was so convinced that we were being scammed. that they took pictures and it was a fake. And remember, I asked her if she could point the camera at herself and hold 3 fingers up.
Yeah,
and
yeah,
prove
yeah.
It was live video we were watching.
Yeah, it's pretty.
But I still can't believe she parked her car so far away from that thing. in a bad neighborhood in the middle of the night.
I know, right? And then it was actually going around that car, and that car just, yeah.
What if something had happened to her? What? Oh my gosh.
Well, she had a lot of people watching her, but she had already been out there a couple of times, hadn't she?
Yeah.
Yeah. So, but yeah, I mean, I don't know. It's
But
scary.
yeah, and I
thing.
remember that all the advice you were giving me. Remember early on, I still remember I was walking that nook as you were telling me, like basically
The
like,
good,
if
the
you
bad,
wanted
the
to
good, the
go-
bad, and the ugly. And there's a lot of unfortunately, there's a lot of ugly.
Yeah.
Mhm.
Yeah, and I
Yeah.
found that there was because I was on a show with this former detective that has a YouTube channel now,
Mm-hmm.
and I thought it was great at first because I thought, okay, he brings some detective experience to
Mm-hmm.
this. This will be great. I have visual experience and it can edit
Right.
videos. He's got that knowledge. Well, then came one day where he's like, you know what? I'm going after these YouTubers and the things that they're saying. He's targeting YouTubers, and I told him, I said, I can't be a part of this. I
Right.
can't be a part of this. And it has taken me so long. I left there. I quit the show.
Right.
But it has taken me so long to like basically get that mud off my foot, my shoe, because everybody they were associating me. Actually, they were things he would say they would attribute to me.
Mm-hmm.
And there was this one guy that was so upset with this former detective. He made a YouTube channel in my name. He called it Jeff H. Productions. And he
Oh.
made these awful videos attacking the detective. So I get this phone call from the detective. He's like, Jeff, you're going to take those videos down. I was like, what are you talking about? He says, you know what I'm talking about, the videos you've got up. It's like, I have no idea what you're talking about. And he said, go to this, go to Jeff H. Productions. I said, holy crap. I said, this is not me. I said,
Right.
you really think I would do that? He wasn't 100% convinced, but the rest of his team,
Mm-hmm.
they were convinced this was my work. And a lot of people were convinced it was my work. It was awful.
Wow.
Yeah, and it was done by this guy that is very talented video editor. And
Oh yeah. They
I was able to figure out it was him for sure, because I know as video editors we like to use the same transitions and wipes and fonts
Mhm.
sometimes. And I was like, I bet I can find something in the video he made trashing the detective and something he made that's on his actual legit channel. And I found this wipe transition. It's exactly 25 frames in both videos. It operates exactly the same. So I knew it was him, but I didn't need to use that because then he ended up doing a video where he made fun of me and he used images from one of my videos. And
Yeah. The
I think it was
unfortunate thing is,
obvious.
if you get any kind of popularity on here, there's always going to be people that have to cut you down. You know what I mean? It's the way it is around here. It's
Yeah.
really, it's bad. People, and it's mostly like bitter people that can't do their own thing.
Right. Yeah, they don't know what
That
else to
can't
do.
move on, and so they are just bitter and petty, and they have to go after somebody, or it's just, I don't know. It's pretty sad that they just can't. There's like, just leave people alone. Like, let people do their thing. You do your thing.
Right.
But
Because I see a lot of them, the your haters.
oh yeah,
Then I see like what's her name? I think her name.
haters mean you're successful. That's what my son keeps telling me.
What is
Yeah.
I think it's Foodie Beauty or something. I think
Yeah,
she's a Muslim
yeah. I've
woman.
never followed her. I know she has a lot of critics too, but I've never watched her.
Yeah, when I watch them for a few minutes and I'm like, oh my gosh, your whole existence is to just make fun of this.
To make
this
fun of
woman?
people, yeah, and a whole channel dedicated
Some-
to making fun of somebody, instead of like, where's your real talent? Can you hold an audience on your own without talking about that person? No, you can't, and they know they can't, and that's why they can't go on. They have to do it, and I've seen it firsthand. When someone is made to stop talking about someone, there's nobody that's watching them anymore, and yeah, it's just
Yeah.
crazy. It's
I
but
mean, it's pathetic for the YouTube creator, but it's also pathetic the people that tune in on a regular basis
and they're joining in.
Oh
on
yeah,
that
and some
hate.
70-year-old women, 80-year-old women, sickly women, bedridden women that say they don't want drama, and they're over on channels like that, like just in witch hunts. But that's what it is. It is, and it's sad. And you know what? When sometimes you say, well, how did this person end up hating you? It can be as easy as not answering somebody's email as fast as they think you should answer it.
Mm-hmm.
And I've heard this. This is not just from me. I've heard the RVers, the one on the van life. They did a whole thing last year talking about harassment. And this one, I think her name is Carolyn. She said, I wish I could tell you, like, these people that hate me so much that there's forums and there's groups and there's channels against me. And you might say, wow, I must be a really bad person to have these haters. But when I tell you that this one's mad because it's some perceived slight that you did. You didn't answer their email fast enough. You didn't say hi in the right way. You might have been in a bad mood when you went on a live and you were a little short with someone. Whatever it is, they go from like love bombing the crap out of you to hating you. And I mean, it's a personality disorder, obviously. There's a lot of mental illness on YouTube. There is. But it's just, it's crazy. There's just such a line. And I can tell you, like, there are people that, like, oh, I want to have this with you. I want to do this with you. And then they can just go and they hate your guts. And not that. I mean, we're talking 3, 4, 5 years down the road. They have so much hate and bitterness in them, they can't even see straight. And they think that you're the problem. You know what I mean? It's like, it's really scary. It's really scary.
Yeah, I had somebody just recently, I posted a comment on somebody's YouTube channel, and then somebody commented after me, and they said, hey, I just wanted to let you know that person that just commented, he's not to be trusted. He's not, basically, I was like, oh, this is a carryover from the detective crowd. Yeah,
and a lot of them too do that. They follow people around and they follow them everywhere, and every time they make a comment, they try to say things, and a lot of times the things are not real and they're trying to hurt that person. So you've got to just, if you didn't see it with your own eyes, you didn't hear it with your own ears,
right,
you got to just be wise, because there's a lot of people that play a lot of games and say a lot of things that are not true without proof, nothing.
Right.
And it's sad. It is. And people believe it, and there's always like some kind of usually it's they're trying
But
to get
now, on
money
the
somehow.
positive side of things, though, I have gotten quite a few people that have commented. They come to me and said, look, I judged you incorrectly. I apologize. I really
yeah.
believed the crap that people were saying about you, and then I did research for myself. And then I look and I see you on live streams, and you're consistently a nice guy, and you never come at anybody. It's like it didn't make sense what they were saying about you, but yeah, it's
And that's
it's
good.
really-
That's good when that happens, and that's happened to me too. And I've had people that have come completely from saying like the worst things to saying, you know what, I was over there for a long time and I just listened to this stuff, and then I said, well, where's the proof of this, that, and the other thing? And I could never get it. And they come back, and I give them, props for coming back and saying something,
Yeah.
because
Yeah, 'cause it's not easy to admit you were wrong about something, and to apologize. And
right, yeah.
but it's scary. Like human nature can be. It reminds me. There was a friend I had in California, and she was telling me about a guy that lived in the neighborhood there, and everybody thought that this guy had messed with some young girl, and they were certain of it. And they stormed and they knocked his door in, and they killed him.
That's
And
what I mean. Yeah.
And it wasn't him. It was.
Yeah.
I mean that this is just YouTube. Thankfully, they can't.
Yeah, but see, it's not just YouTube. See, that's what's going to happen, unfortunately, where this is going to go when you have these hate groups and they're so fierce and they say things like, horrible things about hurting children and stuff, okay? They're going to get somebody that's not mentally okay, and you tell them that this person's hurt a child or this person's done this. All it takes is one to go off and think they are doing something good based solely on the words of one person. And that's why you've seen a lot of channels go down lately, because the I don't know if you, I mean, there was channels that were just, I mean, literally saying, I don't care. They're in another country, that they're going to put out everyone's details. There's, I mean, I can't even repeat. It's just so horrible. There's a reason they're down. But it's, and of course, it wasn't me that did it. YouTube did it. I didn't even have anything to do with it, but everybody would think that anybody that's down is because of me. But anyway, nope. I'm not even channels that I follow. It's channels that somebody told me about, that they were not, I was not even being the one harassed on them. That people were being harassed on them. Even were taking like naked pictures of these people and putting them in their videos. And I'm telling you, it's like the Wild West, but it's getting cracked down on. And God forbid anybody ever gets killed or something like that, and it traces it back to somebody. We're going to see a lot of real consequences to people, because it's not the Wild West, it is real life. And when you're starting to go after people like that and saying the most heinous things about them that can put them in severe danger, with no proof, and just because you're slighted some way, yeah, it's going to come back.
Yeah.
You know, and one way or another. Hopefully it's not the people that are, get killed, because hopefully they can get it under control before that. But it's sad to say, it's the way things are going. It's not good.
Yeah, the anger and the vitriol is just.
Yeah, it's really bad. I
mind-blowing
mean, to
stuff.
have that much anger and hatred in you that like you can't get past that, you've got to really look at yourself and say, boy, I better, do something. And it's just like so ridiculous.
I was just in a live stream tonight, and I was just saying, it's like we were talking about this subject, and I said, look, why I don't understand why you got to be so angry at somebody's opinion that they're sharing today. Next week, they could be saying something. They could change their mind and be in complete agreement with you.
Right,
So
yeah.
why not?
That's what I said about this Maya case. Listen, I have an opinion that's probably not in the popular opinion, and there's people that have that opinion, but I said, it's okay if you think the other way. We have plenty of people here. It's like, you don't have to, end a friendship over this case, and there's going to be plenty of other cases that we agree on or we don't agree on, and you can come up here. Like if you followed that case, Jeff, and you had the totally different viewpoint, I'd say, okay, come on up. I wouldn't be like, oh my gosh, how could you say that, Jeff? Can't you see this? Like how, but there are people that you can't. And then if they hear you with a different viewpoint, then right away they're like, oh my gosh, and then they have to get out the spears and go to like,
Yeah.
Vinky, I want to talk to you. But yeah, I don't know. It's just scary.
Yeah, I think, what's that quote? You can disagree, but you don't have to be disagreeable.
Right. You don't have to end your friend. I mean, and nobody's going to see eye to eye on everything. It's what makes the world go round, right?
Right. Oh, I would much rather. I mean, I enjoy conversations where it's a debate and really causes you to question and test what you believe, and your debating skills, and how well you can articulate what it is that you believe.
Exactly.
And how you can kind of call into question their theory, but politely, just because it can be taken so wrong. Like if you say it the wrong way, especially if it's just in chat, it's like words on a screen can be just so misunderstood.
Right, and it's like when people, why do you have to go right away for the insults? If you're going for the insults, then you can't even support your argument or what your theory with facts, If you have to call the other person horrible names, then you have nothing. You've already lost the debate.
Yeah.
So it's just like, I don't know, it's kind of really
But I like, there's a Bible verse that I like. It says, a soft answer turns away wrath. And so I always am trying my very best to be, now I can be a snarky SOB, but at least I'm still giving soft answers. I don't ever call somebody like a name, or I don't ever cuss. But I can be kind of, what do you call it? I guess maybe passive aggressive.
right, yeah.
But usually with snarky comments that are like sarcastic, but humorous. I try to put humor in it, so like they understand. I was like, because they come at me with fighting words. If somebody comes at you with fighting words, if you come at them with fighting words, then
Yeah,
you know
don't
what you're
forget
gonna
it,
get.
right.
But if you
Well-
come at them with, you know,
Yeah, well, that's like
Love
someone
your
said early
enemies.
on in YouTube, if somebody leaves you like not like a real nasty comment, but, try to diffuse it with some humor, and you might even win them over. Like, I've done that
Yeah.
before, like, you know what I mean? Like, but yeah, if you right away, you're like, oh, you're a jerk, this and that.
yeah, the notion of love your enemies is not easy, but if you can do it a little bit, yeah, you can gain friends. That's the thing. When I told the detective that I couldn't be on his show anymore because he's going after YouTubers, I said, how can I do this with you when everybody's always hearing me say, your enemy today can be your friend tomorrow. You should leave the door open to that. It just doesn't fit. I just cannot be part of what you're going to go do. And he has gotten some, oh my gosh, there's so many people that hate him, and I'm so glad I made that decision to separate myself, because that
Yeah.
and I did it right from the first show. No, I was there for the second show, and like a dummy, I did actually go on I was on the camera with them, but if you watch it, you'll see I sat there for 45 minutes without saying a word, because it was just. And I had somebody comment, and they said, I could see it in your face, you did not want to be there. It's like, how long are you gonna continue this?
Right.
I commented back and said, you were absolutely right. I said, I did not want to be there, and I'm not there anymore.
Yeah. So.
And they, oh my gosh, they got so upset with me, the detective and the team.
Mm-hmm.
Like, I don't understand why you're so upset with me. Because I went on a live stream where somebody commented on the live stream. They said, did you hear? I see Jeff's here. Did you hear he's going to go after what's his name? And I was like, I never said that. That you're talking about the detective. So I went on their live stream to explain it. And then when I talked to the detective and the team in a like a meeting, like, we use StreamYard to do meetings.
Right.
Man, they let me have it. It's like, what did I do? All I did was clear my name.
Right. Yeah.
Plus, the detective. Right now, we're kind of semi-friendly again, which is nice, but still, can't work together.
Right.
But he. Oh, I just lost my train of thought. Maybe it's 3:45. Yeah, shoot, I can't remember what I was gonna say.
Happens to me all the time.
But it's good to know that every I really feel good that because I've decided to never give the vitriol back. It has been working for me, and it's I've got so many people that seem that they respect the work that I do, and the videos I put on my YouTube channel are used as like reference material by a lot of YouTubers. And it's funny though, some of the videos I think that I have on my YouTube channel that answer questions, but those that really think that Kohberger's innocent, and they're like, and I hate this phrase they use. Make it make sense.
Oh yeah, make it make
Constantly
sense.
saying that, but if you
The
don't
math
want it to
and
make
mathin'
sense-
too. They said in math and mathin'.
Yeah,
the
they
math.
really don't want it to make sense. They want to be stumped. They're like, well, clearly he must be innocent because this doesn't make sense.
Yeah, I think it's. But I think they're full of crap. Like I think they really know that. You don't think some of them are just doing it because it's getting views? Like that they really don't believe that they really.
Yeah, well, or I think I think you kind of alluded to it. Like there's a fear. You can tell by the way that they have to say this big disclaimer before they talk about. They'll say like, now I'm going to say something. Now don't hate on me. Don't everybody dox me or diss me, or this might sound like I'm implying that Brian's guilty, but I don't. It's like, my gosh, what happened to free speech?
Oh, yeah.
And free thinking, like I want to throw this out. Can't you be free to just throw this idea out? Maybe it's preposterous. Change my mind.
I just
basically.
think I just think some are just like coming out with, because listen, if you come on, just think about if you didn't have any ethics, right? every night you could go on there and you get one of your friends. Okay, you call in, you pretend you're in the insider on this. Oh, I got an insider on the phone. We're disguising their voice, but they knew so and so, right? And every night you'd have a captive audience in whatever case was the hottest case going on. And there are people that do that, and they sleep like babies at night. You know, but they're definitely, I think there's plenty that know, like the ones I told you about before, they knew 100%, like, this is not a real insider, you know, but they have insiders and this, and I know this, and somebody spotted this person, and she's over here, and she's changed her name, and she lives at this apartment, and then it's all fake, you know, but there's a captive audience, and it's paying the bills, and so they think, okay, who am I hurting? You know, but it really is, you know, it's not fiction. They are people's lives, and you know, if you want to write fiction, then write a good story, or I don't know, but it's like you just can't do all this stuff, and they do put innocent people in danger, and all kinds of stuff. I mean, it's just
Yeah. And what happens to just like feeling good about telling the truth?
Yeah, but
Oh.
see, but the truth takes time, right? Trials take time, so you get to a certain point, and there is nothing new on something, and people are just, I want more on that. I want more on that. You know, there's other channels. They're saying this now because they're just trying to keep that momentum. It's the way it goes, you know. It's just the way it goes here. You wax your wane, you know. And then the next day, there's something big that hits, and there is. Real cases that have a lot of intrigue. I mean, this Adelson case, he's getting sentenced tomorrow. His mother's just arrested, and I mean, it's just, that's a Lifetime movie miniseries.
Yes, it is.
Yeah, that's just, I mean, that's such an interesting case. There are so many real cases that you can, you know, still go down, but they have to stay. That's the one thing, like, nobody ever wants to drop that one case, just like they're talking about Summer Wells. And that's another case that's just gone down a rabbit hole, and that little girl, then nobody got any closer to helping or find that little girl or find anything about her. It was just nothing but a whole bunch of drama. And but yeah, like she was referred to, a cash cow by some really unscrupulous people, and people think that's okay. That's a cash cow, and it's okay to do that. I mean, it's sick. You know, it's a little girl, no matter what, and yeah.
Yeah, that's terrible. That's terrible.
But we're going to end here too, so I've got to see how to end this tonight because it's been a long day. But it was nice. Thanks for coming on,
Yeah, thanks for
saying
inviting
hi.
me. I'm
And
glad I didn't let the clock sway me from coming on, because I almost looked at the clock. Oh, it's
yeah. Well, have a
Talk to
Merry
you guys.
Christmas if I don't talk to you, and
Yeah, same to you. Same to you.
but yeah, stop in. It was nice.
I hope Santa brings you a whole bunch more watercolors.
Yeah, maybe. I'm just trying to think about what I'm going to tell my son. I have to think about him. But yeah, and everybody out there, I'm trying to get to the live to end this baby here. Okay, here we go. God bless everybody. Take care. Love you guys.